Hear, all persons having business with the appellate to draw near, give your attendance, and you shall be heard. Will you be seated?
Good afternoon, folks. Welcome to the First Department. We have over 6 hours of argument, and I'm assuming people would maybe like to get out and enjoy what's left of the day. So ask for the time that you need, not the time you believe that you need to educate us on your appeal, because I can assure you we are all a hot bench. So really focus on the arguments that you think that you need to convince us on. People versus Ramirez. Submitted. Frimer versus City of New York. Four minutes? Okay, 4, 2, and 4. JDD children? Five and 1. And you're attorney for the child? Okay, so 5, 1, 4, and 3. DLK LLC versus Carland B LLC. Appellant. And what do you want for rebuttal? So 5, 1, and 5. Cold Spring versus National Securities.
7 and 3, please, Your Honor, for the appellate.
Okay. You want 6 minutes? Okay. And I want to note that Justice Scarpula is recused from that case. CW Capital Colbot versus CW Capital Investments.
Appellate, Your Honor, 12 and 3. Plaintiff responded, Your Honor, 5.
5 and 2 and 5. People versus Stewart. Submitted. Gowan versus Healy Namad Gallery.
Appellate, 10 and 5.
5, 2, and 5. Respectfully, I gave you 5. Bronxwood Home versus the AG. 7, 2, and 7. People versus Bellamy.
Appellant requests 7 and 2 to cover both appeals. Respondent requests 5.
5, 2, and 5. Maljek versus West 70th Owners. 3 and 5? Wouldn't it be 5 and 3? I will defer to your logic. 3 and 5. And are you a cross appellant? And who do you have, sir? You got the alleged GC. New Order 6 and 2. Okay, so it's 3, 5, 6, 2, and 2. Wesco Insurance versus SR Delco. 4, 3, and 4. Walsom 316 versus 316 Bowery.
Defendant appellant, 5 minutes, Your Honor. The court would like to use argument.
Are you? Is anybody else?
I'm happy to.
Well, it's up to you. You want argument?
Like 5 minutes.
You would. Okay, I'm going to give you 2 minutes.
Thank you, sir.
Kingsbridge 2005 versus Wells Fargo.
Good afternoon, Your Honor. Aaron Lockheim, Walsom, on behalf of the appellate.
Okay, 4 and 2.
Seconding, Your Honor, was fine, 4 minutes.
Got it. 4, 2, and 4. And finally,
Do you want to say that I'm recused on that?
oh, I apologize. Yeah, Judge Gessmer is recused on Kingsbridge 2005. And Algafi versus Ewis is submitted. So first case up is Frimer versus City of New York.
Step up.
May it please the court, my name is Scott Singer. I represent the plaintiff appellant in this matter. Since the city isn't here, I'll deal only briefly with their our argument, our claim against the city, because unless there are questions. So a defendant asserting a integral part of the work defense must offer at least some evidence of the defense in order to successfully oppose a plaintiff's motion for summary judgment. In a recent decision, Castaldo against FJ Siami Construction, this court held that a worker who tripped on a ramp was entitled to summary judgment on his labor law 241-6 claim, noting that the general contractor had failed to
Well,
show.
in this instance, the conduit was protruding from the concrete floor, right?
That's correct.
And what connection did it have really to the work that the plaintiff was doing?
None. It was just a nuisance that had to be eliminated. It wasn't integral in any sense. Everybody agreed.
Well, was work being performed, for example, on the conduit?
Excuse me?
Was work being performed on the conduit?
No, nothing was being done. It had apparently been cut at some point, but it was not going to be part of the new building. And that was agreed by all the evidence. All the witnesses agreed that it was old, it was not going to be used, and I would say as a matter of law, it was not integral. So that's really the only defense that the city asserts. So I don't think there's any defense to our claim, our 241-6 claim against the city. As to Summit, the issues are a little bit different. Summit was a prime contractor. The Supreme Court dismissed our case against Summit, relying on the Espinal case. But the Supreme Court ignored basically a large body of law that permits an employee of one contractor to, even if it's not in privity with another contractor, can proceed against that the other
So it's your contention essentially that Summit launched an instrument of harm, is that correct, under Espinal? And how was that?
By permitting this situation to exist, where this the conduit was not cut down, it was not covered, it was not marked in any way, and that affirmatively we submit created an instrument of harm that plaintiff tripped on. So
The conduit was exposed after a wall demolition?
there had been a wall there. There was testimony that there had been a wall there. It was demolished. Nobody identified who was responsible, who had actually cut this. It appeared to have been cut. Everybody agreed it appeared to have been cut. Nobody knew who cut it, but it had to have been done by either Summit or presumably somebody acting under it, and there was evidence that Summit was the one responsible for cutting these down.
Wasn't part of Summit's work to do necessary demolition?
Yes, they were demolition and general construction. In any event, they didn't present any evidence indicating that they had no responsibility for it. They didn't produce work records.
Well, didn't they argue that they were just acting, or they were performing their job in accordance with the plans, and that therefore they shouldn't be held liable?
Well, the plans, under the plans and under the protocol for this site, they were responsible for cutting it down, the object. But in any event, they presented no evidence that they didn't do it. You know, the burden is on them. They're the parties moving for summary judgment. Show us that you weren't responsible. They produced nothing, absolutely no evidence at all. Their witness, their only witness, didn't know. He says, I don't know who did it. Nobody knew who did it. So it was their burden, and they didn't sustain their burden. So we think we have a...
And my recollection is that they also didn't produce any plans that showed that they had acted consistently with the plans.
No plans, and especially no work records. I mean, how can they even prove a case like that? And their witness, Mr. Gittini, he came in and he said, I don't know. I mean, he had no knowledge of anything about how this conduit was cut down or how it was created or who left it or anything like that. And they should have known. I mean, it was they were the demolition people, so they should have known, but they didn't. So we believe we also have a common law negligence case. We're not asking for summary judgment, but we are asking for summary judgment against the city in light of the fact that there's no viable integral part of the work defense.
Thank you, counsel.
Thank you.
You may proceed.
Good afternoon. I'm Richard Ashnault from the law offices of Kevin Westerman. I'm here for defendant respondent Summit Construction Services Group. A couple of things I'd like to point out. There is evidence that Summit produced indicating that it performed its work in accordance with how its principal wanted it to be done. That was in the form
Its
of,
principal, or,
well, of the city, the owner with whom they contracted.
and where is that evidence in the record?
The witness for the city said, this is as good as it gets. This is what we expect it to
To
be.
say this is as good as it gets doesn't specifically say that Summit met every criteria that they were supposed to meet, right?
Well, there is no ongoing obligation on the part of Summit either. There was demolition work that was done.
So demolition work you agree that demolition work is a part of your client's bailiwick, right?
Demolition work is part of what Summit was doing. There
And the
is no,
conduit was clearly sticking out as a result of some demolition having been done, right?
not entirely certain of that.
Where else would it have come from?
There is no indication of where it came from, whether it was pre-existing, whether it existed before Summit got there. There was
If
speculation.
you haven't shown if you haven't shown affirmatively that you didn't cause it, isn't there still a question?
Well,
Doesn't that leave that
there's a couple
open?
of things I'd like to raise on that. In the Martinez versus Hunts Point Co-op case, that's at 7983rd 569, this court indicated that the Hunts Point, the defendant, was alleged that they had received no complaints about any alleged defect, had no notice of it, et cetera, and this was sufficient for Hunts Point to establish their prima facie case, since, and I'm quoting, our jurisprudence does not require a defendant moving for summary judgment to prove a negative on an issue as to which it does not bear the burden of proof. So here, it is incumbent upon the plaintiff to establish the existence of the exception to the Espinal rule, which they failed to done.
I would suggest to you that you're moving for summary judgment here.
That's correct.
So in the first instance, it's your burden to establish a prima facie for summary judgment, and how, in light of the fact that you are a demolition contractor and a general contractor, there is, near the site of where the demolition work is going on, there's an exposed, unused conduit. Isn't that sufficient to, even if you make out your prima facie, to raise an issue of fact as to whether you launched an instrument of harm?
Well, no, I don't believe it is, Your Honor, because, again, there is no indication of our having taken that out. There was also an electrical electrical prime contractor, and there was testimony that it...
electrical prime contractor wasn't working on this particular conduit, because these conduits were pre-existing, they were older, and they were exposed after the demolition. Is that not?
It's not entirely clear. Again, nobody really knows where they came from. They may have been in the floor to begin with. And again, in order to establish the exception, the application of the exception under Espinal for launching a force or instrument of harm, there has to be some proof that it was made worse.
But it seems that you're trying to meet your burden by pointing to gaps. And I don't necessarily know if that's the standard, because that doesn't mean that you've actually met your burden.
Well, I'm going to go back to, again, where the argument was that we are entitled to rely on the specifications that are given to us by our principal, and the city said this is acceptable to us. They ratified the work, accepted the work, as did TDX.
I looked at that deposition testimony, but the question is not what the witness is saying, but you showing where in the plans that your work was consistent with the plans. That's the issue.
Well, that's what our argument is, Your Honor, that they accepted the work afterwards, and we were done with the demolition work in that particular area of the job, and they indicated their ratification of their acceptance of that work by basically putting Rams Mechanical, who was plaintiff's employer, putting their staging area where that work had been done.
Counsel, if I may, I just want to refer your attention to the deposition testimony of, I believe it's Azad, the senior project manager, because in that testimony, he indicates that it was your client who was responsible for the demolition in that area, and if there was something exposed, a tripping hazard, your client would be responsible.
If we were directed to remedy some sort of situation that was brought to our attention, if it were not to their specification.
And I'm glad you brought that up. Let's talk about the plan. Let's talk about the specifications, because you're saying, oh, we performed the work in accordance with the plans, the specifications. So you're saying that if there was something exposed, that was fine, that would be in accordance with the plans and specifications?
Someone was hired to do demolition to the satisfaction of the property owner and their construction manager, TDX. According to the testimony of both the city and TDX, Summit did that, and that their duty was over at that point. And if there was some indication that Summit had been told to come back and repair something, which there was not, as both the city and TDX testified that they would not have done so had they seen it.
Thank you, counsel.
Thank you.
I just want to point out that in their brief, the Summit contends that it wasn't working at the site. The work was done. It was clearly not done, and there was plenty of evidence that there was ongoing work at the time. And I don't understand there's any doctrine that says the owner has the power to discharge them from responsibility for an accident that they cause. Are there any questions the court has with respect to my claim against the city? If not, then I'll rest on my brief.
Thank you, counsel. JDD Children? You may proceed.
May it please the court, Emily Wall from the Center for Family Representation for the appellant. The family court erred in rubber stamping ACS's applications for the respondent's mental health records, where ACS failed to demonstrate that the records were necessary to the resolution of the neglect case. ACS's application didn't contain any information that would even support a determination that the records they sought would have any relevance to the instant proceedings.
Could you move closer to the mic, please?
Oh, I'm sorry. Yeah. And they made only conclusory statements about the need for the records. This is insufficient to demonstrate that the interests of justice significantly outweigh the need for confidentiality, as is necessary for disclosure of the records under the mental hygiene law.
And I assume it's your position that there's no question that that provision of law applies to Article 10s?
Yes, Your Honor, I think ACS's argument that the mental hygiene law doesn't apply has no merit. This court and other courts have routinely applied the mental hygiene law to requests for mental health records in family court Article 10 proceedings, and both the family court judge and ACS below acknowledged the applicability of the mental hygiene law to these requests.
And what is your position with regard to ACS's statement in their that the mother put her own mental health into issue?
Your Honor, I think there's no question that the mother's mental health condition is at issue in this proceeding. ACS made allegations that the mother's mental health condition impaired her ability to care for the children, and that as a result they were harmed or at risk of harm. But what's relevant is her condition at the time that the petition was filed. And ACS already obtained the records of our client from Bronx Care, where she was psychiatrically hospitalized at the time that the petition was filed.
But despite the fact that their petition said that she was hospitalized in 3 different places on the same day.
Yes, I mean, that's clearly incorrect. She was hospitalized on Bronx Care. At the time the petition was filed, she was not hospitalized at the other facilities, which are not hospitals. And so that was demonstrably incorrect. So the best evidence that they, the most relevant evidence to proving the allegations would be those records from Bronx Care, which ACS already had.
So, counsel, but the mom also said that the first time she was ever diagnosed with bipolar disorder was during that hospitalization, correct?
Yes.
And there was conflicting information about whether that was the first time that that was the diagnosis. So those medical records from the earlier mental health treatment would have gone to test the mother's assertion that the first time she found out that she was bipolar was at the time of the incident, right?
It would, but ACS didn't need those records to prove that because there were prior findings based on the fact that the mother had previously been diagnosed with bipolar and had not engaged in treatment.
Right, but okay, but those findings are in court documents, not hospital records, right?
Correct, but prior findings of neglect are admissible in a neglect proceeding.
But wouldn't the mother need, forgetting about what records we're talking about, in general, talking about mental health records, wouldn't the family court need those records to assess the mother's mental health condition as it presented at the time the petition was filed? I'm not talking about post-petition records, but really pre-petition records.
Well, Your Honor, I think the question is not just whether the records would be helpful, but whether they're necessary to the resolution of the issues in the neglect case. That's what's necessary to meet the standard under the mental hygiene law. And
So let me just see if I understand you. You're saying that because there were these neglect findings based upon mental health issues, these additional records would be superfluous, that you don't need them? I don't understand. If they're not related, then why wouldn't they be able to use them?
right, so Your Honor, for both of ACS made allegations of the mother's mental health condition, of neglect based on the mother's mental health condition, and of derivative neglect based on the prior findings of neglect. But in both of those cases, in order to prove neglect, ACS needs to demonstrate the mother's condition at the time the petition was filed. The evidence in the record, well, the record is clear that the mother hadn't engaged in mental health treatment at any of these at the facilities that ACS sought records from for several years. So those records are not going to be very probative of what the mother's mental health condition was at the time the petition was filed.
Why wouldn't the subpoena be granted or issued, and then the court do an in-camera review to determine that particular point?
I mean, if the court did properly determine that any of the records would be necessary for the neglect allegations, then the court should have conducted an in-camera review to determine whether the standard under the mental hygiene law
Well, that's a separate issue, right? So the question is let's assume, at least I disagree with you, that some records are necessary. Why not allow family court to conduct a in-camera inspection to determine what particular records are material and necessary with respect to the neglect petition?
I mean, I think first there has to be some suggestion that the records would be relevant, and I think it's clear that records from maybe prior to the children's birth.
Well, it's not relevance, right? It's material and necessary as a standard.
Yes. So, but the records from prior to the children's birth wouldn't even be material to allegations of neglect. So I would argue that the court should at least limit the records produced to some relevant time period before ordering them produced.
So ACS said in its brief that the mother admitted having been treated at Fordham Tremont. I couldn't find either any admission by the mother that she'd been treated at Fordham Tremont, nor any actual evidence that she'd ever been treated at Fordham Tremont. I might have missed it. Is there any actual evidence? I saw that one petition on information and belief stated that there was hearsay that she'd been treated at Fordham Tremont. But is there anything other than that?
I don't recall whether in her testimony in the 1028 she acknowledged having been treated at Fordham Tremont, but there was the 2016 petition indicated that she had been treated there and was discharged.
On double hearsay? So there's nothing more than that I missed?
I don't believe so. I don't recall. I believe the mother didn't recall whether she had been treated at Fordham Tremont in her testimony.
Counsel, if I may, there's been a lot of different discrepancies with respect to when the mother received when and where she received certain treatment, even with respect to the certain diagnoses. So why wouldn't an in-camera be appropriate in light of the allegations here that it is, the mother's failure to comply with previously ordered treatment that she neglected the children? Why wouldn't an in-camera for certain records be appropriate in light of these discrepancies, with respect to when she received the treatment and from where, including the diagnosis?
Your Honor, I think if any records are produced, then they should be subject to an in-camera inspection. I think, though, that it's not necessary to get these records in order to demonstrate that the mother hadn't complied with her prior mental health treatment when there's prior findings based on those allegations.
Let me just ask you, the mother consented, March 5, 2018 was a consent without admission, right?
Yes, Your Honor.
So there is some, and the one after that was for corporal punishment, right? Not for mental health.
That's correct.
So it's not clear to me that just putting in those petitions or those dispositional orders would resolve the issue, particularly, for example, when she testified that she stopped taking medication because she didn't need it anymore, and that the first time that she was diagnosed with bipolar disorder was right after this incident here. Those are two very different factual statements than what may appear from the medical records, right?
Yes, it may.
Okay.
Thank you, counsel. Who's going next? Attorney for...
However it pleases the court, I am...
By all means, go ahead.
May it please the court, the Legal Aid Society by Hannah Kaplan on behalf of the subject children. As argued by the appellant respondent mother, the family court erred in granting the orders for the entirety of the respondent appellant's mental health records.
Focus on the pre-petition stuff, because maybe there's a strong argument for post-petition, but pre-petition.
Yes, Your Honor. Are you referring to the 1028 hearing, past findings?
I'm talking about the time period prior to the petition was filed.
Yes. So there are records sought from Fordham Tremont, and there are records sought from Henry Street Settlement at this point. The Fordham Tremont records, in response to Your Honor's question, there was no testimony at the 1028 hearing regarding the mother's treatment because the family court judge, an objection was made and the family court judge sustained that objection, saying, I have the order of disposition, I have the fact-finding order, and I have the petitions from the 2014 and 2016 neglect findings. I do not need to hear evidence to this point. And the court entered a finding neglect based on mental illness that impaired her ability to care for the children in 2014 based on just those facts. And if it was good enough in 2014 and 2016 to sustain a finding of neglect against the children, then here we stand in 2022, and all of a sudden ACS says it's not good enough. I would dispute that point. Furthermore, with regard to what exactly is being requested, if there is any question regarding diagnosis in 2014 and the mother's own admission that was the finding of fact that underlied the neglect findings previously, a narrowly tailored subpoena might get to just that point for the court to have that information.
So you're not arguing about the Bronx treatment facility records?
From the 2022?
Right.
No, those
Okay.
records were not the subject of this. We agreed with the subpoena of those records. That subpoena, I would also note, was time limited to the time that the mother was actually receiving care there as well.
And so you're arguing on the Tremont records, the Fordham Tremont, because they preceded the 2014 and 2000, but the 2001 of those was for corporal punishment, not for mental health, right?
That was the 2019 petition.
I'm sorry.
So in 2014,
Right.
Exactly. The 2014 petition alleged mental illness based on the mother's admission of bipolar disorder. And then the 2016 petition said, again, her mental illness based on the 2014 allegations and that she had failed to comply with treatment at Fordham Tremont specifically, that she began treatment there in 2014 and she was discharged in 2016 due to lack of compliance. And the court made a finding of neglect based on that.
But just once again, the mother consented. There were no actual findings, as my colleague had indicated before, right? 2014 and 2016.
So on consent, pursuant to 1051 subsection A, the court made findings to the entire allegations in the petition. But yes, there could, if there was something specific to that point that that ACS demonstrated they needed in this case that they didn't need to prove neglect in the prior cases, which I don't see, there could be a much more narrowly tailored subpoena or court order to that issue.
But are you saying that there was at any point an actual admission by the mother that she had been treated at Fordham Tremont?
No, because the question was asked and there was an objection and the court sustained that objection. So there was no testimony about that in the 1028 hearing. Based on the 2016 neglect petition, there were statements that she received treatment there, and the court entered a finding to all of those allegations.
But in terms of the findings in 2014 or 2016, none of those explicitly included an admission by the mother that she'd been treated at Fordham Tremont, right?
The statement in the petition, the 2016 petition, I believe is based on an ACS caseworker. It's not the mother's statement. The mother's statement was the 2014 petition acknowledging that she had been diagnosed with bipolar disorder as a teenager, that she was prescribed medication at that time.
But is that specific to the Fordham Treatment Center? I think that's the question.
Her diagnosis.
I think the question is, what in the record relates to the Fordham Treatment Center? 2014, 2016, what happened?
The order of disposition from the 2014 neglect case ordered compliance with mental health treatment. The mother's mental health treatment was following that 2014 petition's disposition was at Fordham Tremont.
What in the record shows that?
The 2016 neglect petition that the court then made.
But the petition was only was hearsay.
Yes, but and then the court made findings on consent to all of the allegations.
So
you're talking about the March 5th, 2018 order of the court?
Yes.
And that didn't explicitly say anything about Fordham Tremont. It just said everything is true.
And everything included the Fordham Tremont, yes, so it did.
Although it didn't, what it included was the statement by somebody else that she'd gone to Fordham Tremont, not an affirmative statement that she'd actually gone to Fordham Tremont.
Not the mother's own statement to that end, yes.
Thank you, Counsel. Any other questions? Thank you.
Thank you.
Good afternoon. May it please the court, Mackenzie Fellow for ACS. This court should affirm the standard is
Counsel,
not...
on page 11 of your brief, you say that the mother admitted to receiving treatment at Fordham Tremont, and you cite 3 pages in the record to support that. Some of those pages are from the mother's testimony and do not include anything about being treated at Fordham Tremont. And the other page that you cite is to the 2016 petition. So what is there in the record that supports the truth of the statement you made in your brief to us that the mother admitted receiving treatment at Fordham Tremont?
The mother consented to entry of the neglect finding. She consented to the allegations in the petitions effectively.
So that's what you're relying on for that statement?
Yes, and certainly the mother has never disputed.
I'm not asking whether or not she disputed it. I'm asking your admission. So you're relying on her admission to the petition, which alleged that the worker who signed that document had been told by somebody else that she'd gone to Fordham Tremont. Is that correct?
I thought that it was the mother that told her that, but
Not in the petition that your
yes.
office submitted.
But then what would the effect of this consent, what's the effect of that in terms of the admissions or the statements that were made inside that petition.
Our position would be that she's really prevented now from disputing the truth of the allegations in the petition because she consented to a neglect finding based on those
But
allegations.
the statement in the petition wasn't that she'd gone to Fordham Tremont. The statement in the petition was that somebody else said she'd gone to Fordham Tremont.
And the mother decided not to dispute any of that and to consent to a neglect
She wasn't
finding
disputing that
based on
someone had said it. Maybe she was admitting that someone had said it, but there's nothing that says that she admitted that she did it.
The record shows what it shows. If Your Honor is not satisfied, I'm not really sure what I can do about that. But the standard here for this, to get the records that we're seeking, is not necessary and material, as my colleagues here have said many times. Neither statute, neither the Mental Hygiene Statute nor the Family Court Act says anything, does not use the word necessary at all. The Family Court Act, which is obviously the act that applies here.
You're saying that mental health law 13 doesn't apply to Article 10 proceedings?
That is the statutes are flatly inconsistent,
Sorry.
frankly.
So you're saying that mental health law 33.13C does not apply in family court in Article 10 proceedings?
That's right, because 1038A is more specific and trumps it, and specifically says hospitals and clinics shall send the records if they are related to a neglect proceeding, period. And it doesn't say anything about necessary. And the mental
Is there any
hygiene,
case law that supports that position?
I can't find any cases that have even addressed it. It seems that the courts have not really, well, first of all, there aren't a lot of appellate division decisions on this subject at all, let alone addressing this specific issue. I don't think any court has confronted.
You take the affirmative position that in 1028 hearings, that Article 10 trumps, so to speak, mental health law 33.13C.
That's right, because the mental hygiene law says clinics shall not release records except in XYZ, and the Family Court Act says they shall send those records to the family court. They're pretty inconsistent, and obviously the Family Court Act applies in family court.
So it's something that we haven't addressed and none of the other appellate divisions have addressed specifically?
That's exactly right.
Is there a way to reconcile both?
I can't see any way to reconcile it. The mother doesn't even address the Family Court Act provision. Her position seems to be that it's just inapplicable and it doesn't matter. But even if the mental hygiene law applies, it doesn't say the word necessary. It requires a balancing act. And the court here engaged in a balancing act and found that the records are necessary, or the court did say necessary, even though that's not the standard, and that it needs them to find out what happened.
But how did it balance the mother's right of privacy?
Well, that thing is, the mother doesn't have a right of privacy because the legislature has eliminated the doctor-patient privilege for family court. It does not apply.
So you're saying that once any proceeding is brought against anyone in family court, that negates all of their privacy proceedings related to their medical care throughout their entire life up to the moment the petition is filed?
No, ACS would have to.
I just want to know what your position is.
No, my ACS's position is that ACS would have to show that the records are related to the neglect proceeding. If it's just some random healthcare treatment, obviously it's unrelated. Now, the problem, I think.
Because if we weren't able to implement it the way that you're saying, then in any case, any neglect case where mental health was an issue, there would be no way to support that, right? Because everybody's medical records would be subject to privacy of the mental health law if you're not going to do the balancing test.
Right, that's exactly right. But here, the legislature has engaged in an assessment of the interests and has decided that it's more important for the family court to have the records to find out what happened and how to protect the children than it is to protect the mother's records. Now, of course, family court records are all confidential, so this is not something that's going out to the whole world. It's just going to ACS. ACS works with the other parties regularly to redact anything that's unrelated.
Well, that's not actually true. It's going to ACS without even the court currently having a chance to do an in-camera inspection to determine if there are records that would be inappropriate, correct?
We're fine with an in-camera inspection if the court thinks that's important, but we also regularly work with the other parties to redact things that are irrelevant. It happens every day in family court that the ACS and the mother's attorney work together to redact things that are irrelevant, and they are not introduced into evidence.
So I'm curious, if both parents were subjects of the neglect proceeding and one parent's mental health records were subpoenaed, would the other parent get a copy of those records since they were subpoenaed?
They might, but you know,
And that person wouldn't be subject to any restraint on what they do with those records, right?
I believe they would because all
What- by
family
what?
court records are confidential.
What would restrain an individual litigant from doing anything with those records?
Well, a parent can always ask for a protective order. There's a specific provision of
In the
1038.
absence of if somebody didn't ask for a protective order, what would prevent that person from doing whatever they wanted with those records?
I'm not sure what would prevent them, but if no one moved for the protective order, obviously the other parent is not that concerned about it. I would say and this is all really beside the point for what's at issue here, where there's only one parent. And I would also say we don't want these records just to find out.
Well, Counsel, I don't know if it's beside the point, because clearly, if you can tell from the questions that we're asking, it's a matter of concern, especially where you're saying that no department has ever ruled on such an issue. So it is an actual matter of concern, because the concern really is, if these, and it happens not just in family court cases, maybe also in criminal cases and things of that nature, where you have these confidential records and they're not subject to any limitation, and there's nothing in the language of the statute or that's coming from the court that limits it. What is that to prevent someone from using that in an abusive way, putting it on the internet? How do we protect that without the mental health law applying?
Sure. Certainly, a family court always has the power to order the parties not to turn over documents to anyone else. It can do in-camera inspections. It can order redactions. There are lots of ways that a family court can prevent that kind of thing. I don't think that this court needs to really be concerned about that. I would like to, before I sit down, speak very quickly. That we're not just looking for evidence that she had bipolar. This is the fourth case involving this family in the last few years. The prior dispositional orders did not work. We need to find out what is going on with this mother and what kind of orders can best protect the children going forward.
But I mean, with respect to the Bronx, the Fordham Tremont, right? What in there is going to be relevant to what's going on now? The court has already held she didn't need those records because there was a finding of neglect based on mental health issues. And the question is not really, the question is from immediately prior or the couple of years prior to when this last incident, or I guess 2018 to 22. Why do you need to go back to 2014?
We actually don't know when she was in treatment at Fordham, and I think that's...
So that's exactly what...
Your allegation is
it's
14
like
to
a
16,
fishing.
as I recall, right?
Yeah.
I mean, so
why are you looking for
aren't
those
you bounded
records?
by that?
You know, those records do show that she was engaged in some treatment, and then we think, well, we haven't seen them, so we don't know what they show. But we think they show that she refused to engage in treatment, and eventually they kicked her out of the program. That is certainly relevant to helping the family court decide what dispositional orders are required going forward. The mother's history of treatment or lack thereof, lack of cooperation, is certainly important for the family court to know going forward to protect these children
So
in
it
this
would be
fourth...
sufficient for you, if the subpoena was issued, then the in-camera inspection by the court says it's not material, not necessary, not related, that's okay?
We don't object to an in-camera inspection. We think it's burdensome to the court, and we do this kind of thing all the time, so we don't think it's necessary, but we certainly don't object. If the court wants to look at it, that's...
Thank you, counsel.
Thank you.
I just want to make 3 quick points. First, this court has addressed the applicability of the mental hygiene law to Family Court Article 10 proceedings in the matter of Dean T, 117 83rd 492, and Briani T.
117?
117 83rd 492, and Briani T, 202 83rd 408. Those are both cases that were about mental health records in Family Court Article 10 proceedings where the court applied the mental hygiene law.
How do we balance the two? Can we reconcile both and apply both statutes in a way that's reasonable?
Yes, I think the minimum standard under Family Court 1038 is that the records must relate to the neglect allegations, but then the mental hygiene law imposes a higher standard specifically for mental health records. Family Court Act 1038 applies to all hospital records, all agency records, but the mental hygiene law imposes a higher standard for mental health records. And so that would still need to be met before any mental health records are released. And I would just say, I think ACS would love if they could just file a petition alleging mental health allegations and then
But that's not what's happening here. That is not what's happening here. This is someone who's been through several proceedings. So let's just deal with this proceeding.
Well, Your Honor, they did seek mental health records from Success Counseling Services where there's no information in the record that.
Right, but they've withdrawn that. So let's talk about the ones that they're still seeking, right?
And in those, for those records.
Nobody has a problem with Bronx. The other two are the ones.
Right. We didn't appeal
As to
from.
Henry Street, she admitted in the 1028 hearing that she had gone there, correct?
Yes, she
It's really
acknowledged.
Fordham Tremont.
So Henry Street, she hadn't been in treatment there for several years prior to the filing of the petition. So that wouldn't be super necessary to prove what her condition was at the time the petition was
Wouldn't a
filed.
more appropriate way, I understand what you're saying, is to have the court do an in-camera inspection and let the court make that determination as opposed to all of us blindly acting just now because we don't know what the records show.
I mean, I think the records could still be limited to relevant time periods before the
So that's what you want. You want us to limit it, what's your limitation? Is it like 2 years prior? I mean, what's?
Yeah, I would think, Your Honor,
But
that,
isn't that a random number? Shouldn't it be sort of based on what the facts of the case are as opposed to
last
coming
finding.
up with a number of our own? How far would we go back?
Was the last finding in 2018, right?
the 2019 petition was decided, I believe, around 2021. That's when the dispositional order was issued.
But
So I
that
would say-
was that a mental, was that
no,
regarding?
that was not
Right.
based on.
I'm talking about the last one that had to deal with mental health,
That one was, the fact-finding order was March 5th, 2018.
2018, right?
So 2 years prior would be 2016 if there was an artificial 2-year limitation, for example,
Okay.
right?
Right, I don't think there should be any specific length of time necessarily, but I think ACS has to demonstrate in their application for the records the relevance or the necessity of obtaining those records in order to meet the standard.
Well, I
of the
mean, don't you
mental
think
hygiene
they've
law.
demonstrated at least partially that because she's denying any of the diagnoses, and she's denying that she needed the treatment, and she's stating affirmatively that the mental health care providers told her that she didn't need treatment anymore. Don't you think that makes those records relevant, at least some of them?
To the extent that those, I do agree that those might have some probative value. I think that they are less relevant than the records from Bronx Care, which they already have, and which would be the most relevant.
But are you still objecting to the subpoena as to Fordham Tremont and to the other one, and Henry Street?
Yes, we are objecting to.
But only as to the time frame or something else?
Well, I believe that ACS, I mean, we're objecting to the order directing that those records be turned over in its entirety because ACS didn't demonstrate that the need for the records to meet the standard under the mental hygiene law. But if this court thinks otherwise, then I would ask at a minimum that the subpoena be limited to relevant time periods and that an in-camera review be ordered.
Thank you, counsel. Thank you all. DLK LLC versus Ireland.
Good afternoon, Your Honors. May it please the Court, Lavinia Torun, Zelenit, Shapiro, and D'Agostino PC on behalf of the plaintiff, appellant, DLK LLC. We are here today with respect to the Court's decision that granted respondents' motion for summary judgment and declaring that pursuant to the deed, Respondents Unit 2 has an easement over Appellant's Unit 4.
So, counsel, I have a fairly specific question. And it seems to me from the record that your client's architect realized in early 2016 that the unit was 4 feet 10 inches smaller for a length of 27 feet, but that you didn't do anything about it until July of 2018, more than 2 years later, when you informed Ireland and MedRight of the encroachment. Why did you wait 2.5 years?
I believe, Your Honor, I believe the managing agent of the appellant testified that she tried to reach out to Kierland or MedRight, who is the tenant at the property, but they
tried for 2.5 years and were unsuccessful, and they just kept trying?
Yes, I believe
they didn't sue or anything during. Why didn't they bring suit sooner if they were unable to reach the parties they thought were relevant.
There were some communications back and forth trying to measure the unit and trying to get to a mutual agreement. However, that didn't go anywhere, so they decided to file this case.
But that was another 2 years before they then filed, so that was 4 years from the time they learned of the problem.
Yes, Your Honor, that's correct.
So going back to the original time, would it be fair to argue that your client had inquiry notice, despite the fact that Unit 2 easement was never recorded?
So first, Your Honor, we submit that at the time appellant took title to the Unit 4, there was no, respondent did not record the deed against Unit 4, and no such deed alleging a claim of an easement was ever recorded against the Unit 4.
I understand that, but the question is whether you're on inquiry notice. You know there's been a renovation. It was one unit, got divided into 4. Unit 4 is the smallest unit, correct? It was purchased as is. There are various condo docs, correct? The amendo condo plans and other documents which talk about easements and the like when they're renovations. Isn't that sufficient to put you on some kind of inquiry notice?
I submit it's not, Your Honor, because the conveyance here to both plaintiff and to both appellant and respondent was made subject to the provisions of the declaration, bylaws, and the floor plans of the condominium. And here, the floor plans contained in the amended declaration recorded on July 9 of 2010 shows the demising wall in its correct location. So,
Counsel, what place in this, in your argument, does the testimony from the property manager come into play, where admittedly there was no due diligence done prior?
yes, I believe the managing agent for the appellant admitted that the attorney who hired for the closing, they didn't do any due diligence. But even if, I guess even if they did, the floor plans in the amended declaration show the demising wall in its correct location. So I believe that's not sufficient notice to put them.
Well, how did you find out about how did you eventually find out about the wrong placement of the wall?
So during the testimony, the appellant's managing agent testified that in 2016, the condominium found out that the walls are incorrectly placed in the building, in the commercial units on the basement. So one night, I guess the condominium came and moved the walls in appellant's unit, so she didn't have access to the bathroom and more in her unit. So because of that, she hired an architect, I guess.
So couldn't she have done that at the time of the purchase?
She could.
If you're buying it as is, right? With notice that there are easements for party walls or adjoining walls, right?
Yes, Your Honor, but I submit that she didn't have notice about the easement. And in addition to that, one last point I want to make, that to the extent an easement exists, it's undisputed here that the only party benefiting by this easement is the respondent, because their unit, it's bigger, and my client cannot use part of the unit where the wall was erected.
Counsel, if you can you address the specific language in the deed which indicates that the transfer of ownership would be subject to easements in favor of adjoining units for the continuance of all encroachments of such adjoining units now existing as a result of the construction or rehabilitation? It's right there in black and white.
I'm sorry, I didn't hear that.
I said it's right there in black and white, but I'll repeat the language, that transfer of ownership subject to easements in favor of adjoining units for the continuance of all encroachments of such adjoining units now existing as a result of the construction or rehabilitation. It's right there.
I understand, Your Honor, but I believe the deed was presented only at the closing, so it was not presented to them before that.
But they could have read the deed at the closing,
They did, Your Honor.
or the next day. I mean,
They did, Your Honor, but we respectfully submit that because the floor plans filed when the amended declaration showed the wall in its correct location, I believe that that it's not enough to show that there was an easement.
Thank you, Counsel.
May it please the court, my name is Tom Sherwood. I'm the attorney for the respondent.
Counsel, it appears that largely your adversary's position rests on the fact that this easement wasn't recorded anywhere. They wouldn't have known about it, regardless of whether they did inspections or read the deed. It's really your burden.
Yes, first of all, the language in the two deeds, counsel complains that the deed to my client was not recorded against the tax lot for her client's property. Her deed was recorded against her client's property at that closing. The language in the two deeds is exactly the same. So for her to complain, you didn't put us on notice of your claimed rights to have an easement if the property encroaches. It was her deed. It was exactly the same language.
Well, but that doesn't, I'm not sure I agree that it means that the next deed's going to have the same language. The question is what I posed to your adversary is was the appellant on inquiry notice here?
Yes.
To exercise some due diligence?
Yes, I would say absolutely, Judge. There is inquiry notice in all the cases. If you are in possession, if someone is in possession of the property that you intend to buy, that can be inquiry notice. And that, according to counsel's brief, the encroachment was so severe that it deprived substantial value of their use of the property. So they're not saying it's a couple of inches where it might have been overlooked. They're saying this is a big material encroachment. We're in possession of it. We bought a year before. So in other words, for them to suggest that that should not have raised any eyebrows, they decided they weren't going to measure. There was inquiry notice from the purchase agreement that they signed that said this is strictly as is, subject to your own investigation.
Why didn't the sponsor just file the easements against all 4 units?
Why didn't my client file an easement against all?
Yeah, why not just file the easements against all, with the deeds for all 4 units?
he's not the sponsor.
I'm saying the sponsor. Do you, oh, that's right, you're not the sponsor. I'm sorry.
I'm sorry, that's, the respondent is my client, Judge. We believe we have an easement based upon what's in our deed. It says
Right.
together with.
Right.
Together with an easement.
Right, this is not a question for you. You're not, you're the subsequent purchaser, right? But there was no indication why the sponsor did or didn't file the
There's nothing
easement.
about the sponsor having filed anything other than the declarations in the floor.
Well, when the deeds are,
The deed, I guess,
the original deeds, right?
yes, the deed into us, I guess we recorded, Judge, but it's, we recorded it where we recorded it. A couple of things. First of all, contrary to something counsel said, there is a specimen deed in the offering plan, and it's in this record. It's got exactly the same language in it. So to suggest that they were surprised, I don't think obtains. But, Your Honor, just to follow up with the inquiry notice, they knew or they should have known that this was a new construction, that these were adjacent units. They saw this language in the deed. They see the language in the contract. And they elected not to do anything about it. The testimony in the record is we bought it based on financial considerations. The purchase price, the rent from the lease that we had was occupied.
Is there any dispute that this was a smaller space, and there's stuff in the record about it was hard to rent, et cetera, et cetera? Is there any dispute about that?
Judge, it's about a 6% reduction when we do the math based upon what's in the record. They lost approximately 130 square feet based on their dimensions, assuming that they're correct. I think that the gross, according to the deposition testimony, and I think that's at page 208 of the record, is that the gross space here was about 2,100 square feet. So they lost about 6%. To suggest that
Gross
that's
space in their unit?
they're talking about their unit now, yes. That they say that if they had what they think they should have had, it was 2,108 or 2,106 square feet. I do my math, and I could be off by a couple of feet, about 134, 130 square feet. You do the math, and it's about 6.5 or 6.6%. That's not a taking of all value. It's a slightly small unit. It was occupied by a martial arts studio until about 2016, according to the record. So they should get another martial arts studio, perhaps. You know, it's not valueless. 2,000 square feet of retail space in Manhattan isn't worthless. It just isn't. I mean, it's a little bit less than
2,000 square feet because it's minus 130.
Well, you know, Your Honor, they bought it.
Right,
They bought
I
it.
understand that.
Maybe they didn't even look at it, but they bought it. And now they have it. Thank you, Judge.
Thank you.
Your Honor, I just want to make one more brief point, is that the fact that the demising wall is encroaching on my client about 4 feet and 10 inches in depth. It's not the only issue in like renting the space or making it smaller. My client testified that because the board moved the walls on the other side of her units and she no longer has access to the restroom or to the utilities in the building, she tried to build the restroom. However, the DOB plans get rejected because her actual place, as it is right now, does not match the floor plans file.
Is that all in the record?
Yes, Your Honor, it is. So that's another issue here. And in addition to that, Your Honor, we respectfully submit that the only party benefiting from this easement is the respondent, while it deprives completely the appellant of the use of that portion of the land. Unless the court has any questions, I will rely on my brief.
Thank you, counsel. Thank you both.
Thank you.
Cold Springs versus National Securities. Judge Scarpula is recused. You may proceed, counsel.
May it please the court, I'm Stephen Legman. I represent the plaintiff appellant. We are not here asking for attorney's fees. We're not trying to convert this into the British system where the loser pays the attorney's fees. We're here because an action was commenced, not without probable cause, without any cause. The transcript that I've quoted at length in the main brief sets forth they had absolutely no basis for any allegation that was made. This whole action was brought for an impermissible purpose. The defendant in this case, the plaintiff in the underlying case, didn't want to recover anything. They didn't come to the court for a legitimate purpose. They came to file this and then to use that to publicize it, to use it in FINRA arbitrations, to serve subpoenas on attorneys so that Cold Spring will not be able to pursue its business. What we are asking for, and what we've laid out in the complaint, is to be reimbursed for actual special damages, damages that we incurred, consequential damages from the acts of the defendant in this action. The defendant brought this case, the underlying case, for no reason other than to try to cause injury.
What facts have you alleged in the complaint as to the lack of absence of probable cause for bringing the underlying lawsuit?
Well, Your Honor, we have 4 pages in the complaint of allegations saying you allege this, you didn't have a basis for it, it's not true. It concludes in paragraph 55 of the complaint where we said there was no probable cause, but that's preceded by 4 pages of allegations of things that they've alleged that they had no basis to allege. For instance, we had their list and we solicited their customers. They claimed 80,000 customers. They said maybe 3 customers were called out of 80,000. That's evidence that we had the list. When we asked, where's your list? I don't know. Any evidence it was breached? No evidence it was breached. Every single thing they did was simply for the purpose of trying to cause an injury to Cold Spring, to try to put Cold Spring out of business, not because they had any legitimate claim, not because they wanted to do anything. Why did they voluntarily discontinue? They voluntarily discontinued because they knew the summary judgment motion was coming. All they did was try to prolong this case. One of the defendants in the underlying case filed a bankruptcy petition. The action was stayed. The other defendants moved to sever so they can get the case resolved. The plaintiff opposed that. What plaintiff opposes moving his case along? A plaintiff that it's not sincere about seeking redress for any wrong that was done. This plaintiff in the underlying case, the defendant here, didn't seek any legitimate damages. It only wanted this case to stay open as long as possible, to use it in FINRA arbitrations, to serve subpoenas on attorneys, to try to put Cold Spring out of business. We've certainly stated a valid cause of action. We've laid out all the elements of malicious prosecution and respectfully submit that the order dismissing should be reversed because we should have our chance for our day in court to prove the allegations of the complaint.
Do you want to address the de facto merger allegations with respect to B. Riley?
Yes, Your Honor. We have markedly different positions on this as to what happened. We've made allegations, but it's not just we picked these allegations out of the air. As a matter of fact, my reply brief sets forth exactly where. There are news articles that are quoted. There are Google listings. As a matter of fact, I even submitted an affirmation. I called the National Securities number, set it forth in the brief, set it forth in the affirmation. It was answered, B. Riley, how may I direct your call? Go on the website for National Securities. We are now B. Riley. News articles say we share co-CEOs. We share the office in Florida. They took over, according to news articles, not out of the figment of my imagination. There were 547 registered representatives. They took just about all of them. They took the business of National Securities, rolled it right in, and it's just a continuation of the same business.
So is it your,
I'm sorry, go ahead.
is it your position that we should treat defendants, National Securities Corporation and B. Riley the same in whatever we do?
Well, B. Riley did pre-exist, but it's a continuation of the National Securities business.
Isn't there some, in the merger documents, there's some reference to a company folding, companies surviving companies, and it doesn't really necessarily talk about the things that you're saying, the board members surviving and things of that nature. So how can we relate that?
Well, Your Honor, first of all, we're at the pleading stage here. I know we were criticized by the defendant's brief not producing evidence. We're at the pleading stage. My complaint is supposed to be deemed to be true. I didn't really have to come forward with the underlying facts that we set forth. I don't know where they came up with these allegations. I frankly don't understand.
The allegations, it seems like they're coming from newspaper articles and Google searches, and which are really not probative, right? And with respect to even on pleading stage, you can't plead just legal conclusions. You have to plead facts. What are the facts that support a de facto merger where the shareholders of the predecessor company are now part of, for example, B. Riley?
Well, it was, we have co-CEOs. We have a website that says we're B. Riley now. We have a phone number that's answered B. Riley.
Right, because they purchased the company, right?
They rolled it into, and it's a continuation of the National Securities. National Securities is out of business. It may not have formally dissolved, but it's not doing any business. It rolled its entire business, its personnel. And again, if anything, if there's a question of this, certainly the allegations of the complaint are sufficient. I should be permitted to take discovery. I concede, perhaps, that at the end of discovery, maybe I wouldn't be able to prove that case, but this is a 3211 motion to dismiss. The allegations of the complaint are supposed to be deemed to be true. I don't have to come forward with evidence. I did to show that.
Excuse me, counsel, what if any allegations did you set forth regarding continuity of ownership and shareholders? What if any allegations did you set forth?
Yes, Your Honor. The allegations were that they now merged. It's a de facto, if not a de jure merger, that there are co-CEOs. They're acting out of the same office. They're using the website, the phone number, the same, all of the representatives of National Securities, became the registered
Was there anything in the record that would indicate that they also took on their losses or their liabilities or anything like that?
Well, Your Honor, I don't know if I could establish that. I have to find out in discovery certain facts, but with a de facto merger, it's deemed to be the acquirer is deemed to have accepted as taking a continuation of the business the liabilities, and perhaps I do concede the possibility that after discovery I wouldn't be able to establish that, but certainly the allegations have been made sufficient to allow us to get to that point, and I would respectfully submit that the order appealed from should be reversed, the orders. Thank you, Your Honors.
Thank you, counsel.
I please the court. Excuse me, David Kleinman of Tartar, Krinsky, and Drogan for the respondents. The fact missing here is that National Securities did not have a corporate transaction with B. Riley Financial. There's a conflation here of different corporate entities, and the merger agreement in the record clearly shows a purchase in cash by B. Riley Financial related companies. The company purchased was National Holdings, which was a publicly traded company. National Securities was a subsidiary of National Holdings. So B. Riley is a holding company. It can't be a successor to National Securities, which is a broker-dealer, and registered representatives can't go from National Securities to B. Riley because B. Riley Financial isn't a broker-dealer. It's impossible. The nature of the transaction being in cash means that the first element of de facto merger can't be met because if you buy something in cash, you don't have prior shareholders becoming subsequent shareholders.
So your adversary argues, and there's well-settled law to support that. This is a pleading stage motion, and his allegations should survive sufficient to conduct discovery, even if maybe they don't survive summary judgment. How do you respond?
I say documentary evidence flatly refutes it, and I also say that Justice Rosado didn't reach that issue. So really, while I respect what appellant has argued here so far, the issues I believe before the court are the dismissal on the basis of the absence of special damage, because the court specifically said, I'm dismissing it because of the absence of special damage for two reasons. It isn't pled, and the documentary evidence says that even if possible, probable business could be and create a special damage, the documentary evidence still refutes it. She reserved on the other elements of malicious prosecution, and she dismissed B. Riley because of the absence of the underlying cause of action. So the extent that that court didn't issue a ruling, I don't understand why it's being argued here. I think it would go back down should the court disagree with the dismissal on the basis of the absence of special damages on those two bases for the court to issue an opinion on the remaining elements.
Are you suggesting that we don't have the jurisdiction, I guess, to consider whether or not to keep B. Riley in the case or not?
I'm suggesting that this court can do what it thinks is right, as the answer every time I've heard that question in every court. But realistically, there is no possible de facto merger claim as to B. Riley. They're confusing a trade name of B. Riley with an entity called B. Riley Financial. We put in documentary evidence that the co-CEOs are not of B. Riley Financial, it's of a different B. Riley entity. So we've tried to explain to them, and we've put it in the record before the court, exactly why there can't be either a de facto merger or mere continuation theory here. Because again,
So you're saying that the B. Riley that they're referring to is the one that's referred to in the merger documents as the merger sub?
Actually, it isn't. I mean, I think the B. Riley entity they're claiming received registered representatives is a different B. Riley entity. It is neither B. Riley Financial nor B. Riley Merger Corp. For there to be a successor relationship here or a mere continuation, which are very, very closely related, National Holdings, which was the purchase entity, would have to actually end up owning B. Riley. And the reverse is true. And we know that because we have a merger agreement, which it's a reverse triangular merger, which shows that B. Riley bought shares in cash from National Holdings, and then it ended up merging with a B. Riley entity. As to the, I think the main course here, there isn't special damage here because I think the Court of Appeals said that the concrete harm needs to be lost clients. That's really the purpose of this appeal, is the dismissal on that basis. And after the...
Can we make that finding as a matter of law? I mean, based on what the allegations are in the complaint, that in terms of what was what the underlying conduct was?
Absolutely, because it's not really relevant what the conduct was to find whether or not there was special damage, because you have to show a legitimate business relationship that was terminated.
Yeah, loss of clients. I mean, the allegation is that you were, or someone was cold calling, not you, but the predecessor was cold calling clients.
Well, so they weren't alleged to be clients. They were alleged to be people that they contacted that said they had agreed to receive a potential contract. But their own website says that there's no client relationship until after a contract has been signed and the retainer amount is paid. So they have a real issue because they themselves did not consider these 20 people to be clients.
But there is that deposition testimony, right, of the national, that's not the basis of the motion.
That's not the basis of the motion.
I agree, but in that testimony, there's reference to specific clients receiving unwanted phone calls. Wouldn't that maybe suggest special damages, loss of...
Those were those were national securities clients receiving, I believe, unwanted phone calls by Cold Spring, not the other way around.
Okay, got it. Right.
But in terms of the relationship, those individuals had turned, and where you're saying that they didn't, there's no relationship on, at least according to their website, unless the retainer had been signed. And I agree with you, that's what it showed in the documentary evidence. But there were other factors, right? There were certain documents that were turned over in furtherance of that relationship before the retainer. At least that's the allegation.
There are none that have been provided, and there's a real judicial estoppel issue here, which again is, I think, the big piece in the main course. They alleged defamation claims and special damages to have occurred based upon a campaign of malign activity and defamation that was so widespread that it couldn't be avoided. It was viewable in every Google search. It made them lose every client, and they alleged it in 3 separate lawsuits, not against my clients. 3 separate times. They got a mandatory injunction in one of those cases in 2019, and when you get relief that is of that nature, whether it's dismissal or a mandatory injunction, that creates a judicial estoppel. You can't turn around and come to court and say, wait, other people caused the loss of those same potential clients. And you can't claim that whatever this one lawsuit did is now the reason that these same potential clients that were the basis for special damages allegations before caused these lost clients. And they're I mean, that's what the court referred to. It's both their own statement that there aren't client relationships until retainer agreements are signed and money is paid, and this judicial estoppel. And I'd just like to point out that there can't also be special damages here because they haven't alleged actual damages. They've alleged lost revenue. So, and there's a difference there between revenue and damage. They've alleged lost revenue. These cases say you can't plead round numbers, and there's nothing more round than pleading lost revenue as opposed to lost damage.
Thank you, counsel.
Thank you.
As far as the issue of special damages, we didn't just allege we lost business, and that's not sufficient. This court held it's not sufficient. The Court of Appeals in England said it's not sufficient. You've got to be specific. We gave 20 names of people that had agreed to retain us and were going to sign a contract. I agree.
Correct. Paragraphs 56 through 58. And then you attach as Exhibit B those 20 persons who initially said that they would sign the retainer agreements, but then upon learning of the lawsuit, they chose not to go forward with the business. And then the other actions, these individuals were not even named in the prior actions.
Which is why they didn't sustain their burden on a judicial estoppel. They'd have to show the identity of the parties.
But what about your website where it indicates that they're not clients until the retainer is actually signed? Did you produce a retainer?
Your Honor, the retainers were not signed. The distinction here that the defendant is missing is that we don't have to show a breach of contract. This court has said we have to show an interference in a business relationship. And there's even a case, I think it was from the third department, where they talked about the loss of a potential purchase. We had a business relationship with these 20 people. We set forth exactly the amount of retainers that they were going to pay. We didn't just say generally. We didn't just pick round numbers. We had the exact numbers. And this was an interference in those business relationships. I concede the contract hadn't been signed, but there was a business relationship. And certainly, this is not a case of just general damages. We heard our reputations being harmed. This is not right. We've been very specific. I respectfully submit we've established the necessary elements for malicious prosecution.
Thank you, counsel.
Thank you, Your Honor.
Okay, CW Capital Colbert versus CW Capital Investments.
Good afternoon, Your Honors. Brian Slipikoff from Duane Morris on behalf of Appellate. I'd like to introduce Paul Cronus from our Chicago office, who's been admitted pro hoc vice by this court to argue the appeal. Thank you.
Very well. Please proceed, counsel.
Thank you, and may it please the court. I wanted to start off by making clear that we are not arguing in any way that a protective order, even a protective order that has an attorney's eyes only provision, is never sufficient to protect against the disclosure of confidential information. Our position is that in this case, with the idiosyncratic facts that exist in this case, yes, even a protective order that has an attorney's eyes only provision is insufficient. And I'd like to give some examples of those specific facts in this case that make that true. Well, there are real life experiences that we've had in this case that show that the AEO designation, while well-intended and supposedly a good protection, doesn't work. For example, we had PIMCO that had possession of documents, and they turned confidential documents at issue, they turned them over, notwithstanding a protective order, and they did so without the knowledge nor the consent of the servicers whose information that they were providing. That's just one example. Here's another one, and it involves counsel. There was, before the referee, discovery referee, there was a conference call and amongst the parties, and during that conference call, the referee...
Counsel, aren't those issues that can really be dealt with by Supreme Court if there are problems with respect to disclosure of documents, documents falling into the wrong hands? Isn't that something that the court can address below?
I'm sorry, Your Honor, could you repeat that again? I didn't hear you.
The concerns you're raising, aren't those issues that can be addressed by Supreme Court with respect to the documents?
As opposed to this court?
Yes.
No.
Why?
Well, because there's a number of reasons. One is because it's also a dynamic situation that's been created that has produced further information that shows that they don't need these documents. I'll give you a specific example.
No, we can only deal with the record that we have, right? That existed with the trial court. And the trial court found that the documents were relevant. Clearly, I don't think there's any real dispute that they are relevant to the issue of whether or not this was something that all the other services were doing, and there was to prove sort of like a pattern and practice of what everybody was doing at that time. So I can't imagine you're going to argue there's no relevance to the documents.
Well, actually, Your Honor, I think that there are real reasons why to demonstrate why they aren't relevant. For example,
so tell me why there is zero relevance, because we're not, liberal discovery in this state. So they literally have to have nothing to do with the case for them to be not subject to disclosure.
So the issue in the underlying case, it's a breach.
I think I've been on this case before. I know what the issues are. We all do. We all read right. The issue is whether or not there should have been a negotiation of a split of a fee. And the question is whether that was standard in the industry at that time, where everybody was doing it except for the defendant, right?
And the purpose of that provision was to establish that there was an obligation for them to act in accordance with the industry practice.
So, documents showing that all the other servicers in the industry at that time were doing fee-splitting arrangements in their service contracts. You're saying that would have no relevance.
What I'm saying is, if we're talking no, zero, I'm sure that anyone could come up with an idea as to why it would be relevant.
Again, we have a pretty liberal discovery in this state. So you'd have to say, no, it's not at all relevant. And unless you're willing to say that, then we move to what can we do to protect the information then?
Well, I think that there are reasons why they're not relevant, Your Honor, and here's one of them. One of them is that the underlying claim is consistency with industry practice. The CW had to operate in accordance with the industry practice, but CW, because this information is confidential, they didn't know what the industry practice was, so how could they possibly have known what they had to do to comply with that industry practice? And therefore, there's no relevancy to the documents that, the secret documents that other servicers may have, because it's not, CW could never make use of that information. Other reasons why we believe that, well, actually there's a lot of reasons, but
Well, couldn't they have learned that information from doing other deals and engaging with other parties and implicitly learned that?
Even if they hadn't seen the documents before?
There are a number of agreements that the servicers have with respect to these fee-sharing agreements. And those agreements are bespoke. They are idiosyncratic to the deals, each of the deals themselves, each of the terms, each of the conditions. The notion that by getting these documents, that they can then create an industry practice for which they can claim, oh, this industry practice wasn't followed. The documents are different. They are, as we said in the record, bespoke. They are specific to the individual transaction. There was another point that I wanted to raise with respect to why, even with an AEO designation, there's not sufficient, basis to that even the AEO designation is insufficient here, and that is the referee had this conference call with the counsel, and there was a discussion that was prompted by the referee asking the question whether CW's counsel could confirm that he would not use proprietary information when advising CW, okay? So the AEO exists, but the referee is putting him on the spot saying, can you confirm that you're not going to use this confidential information? What was his answer? It was, the counsel acknowledged that he would not be able to unlearn the information that he learned. AEO
No, that's an incomplete answer. He said, yes, I would do that, but obviously I can't unlearn. I mean, it was a snarky little answer, but he clearly said that he was going to abide by the order, and there's no indication that he's not. And if he wasn't, the trial court has tons of contempt powers, correct?
He couldn't unlearn the information, and he couldn't make a representation that he would be able to, in the future, sufficiently compartmentalize that information so that he wouldn't use it. My point is those are two specific examples, not from another case, but two specific examples from this very case where the AEO designation did.
How old are these documents, counsel? Over a decade old?
Some of them are. So the period
between 10 and 13 years is my, at least according to my notes, correct?
Yes, there are.
So in terms of industry standards today, what's occurring, we're dealing with really ancient documents in a sense, right? Because the industry has moved, obviously, over the years. So aren't your concerns maybe respectfully overblown here, given how old the documents are, or the fee-sharing arrangements are here?
So this is the notion that there is a staleness to these documents over time, and that what was in them before is not relevant to today's today's situation, and that's not the case because these loans, many of them are 10 years or more. And so the terms, the existing terms at the time are still in place, and there's been no evidence that's been provided that the terms that have been used, that are being used now, are different in any material or other way from the agreements that were executed years ago.
So, counsel, let me ask you one last quick question. You're saying that there'd be no relevance to plaintiffs' experts in looking at these agreements to try and determine damages for the failure to negotiate an agreement like that? That these agreements wouldn't be relevant?
I think that the record demonstrates that the experts do not need to look.
No, that's not the standard on discovery, though. Again, the standard is all material that could reasonably lead to information that would be helpful. It's not, there's nothing, you can't get it from any other source or anything like, this is just regular discovery.
But in this case, they already have documentation. I think it's 150 different agreements that have these fee-sharing agreements. So that already exists. We know that. Do the experts need more? No, because the expert reports have already been submitted, they've been filed, and they've moved for summary judgment.
One second, let me ask you, did they have, was this discovery exchanged? Has it been exchanged?
So we have submitted a motion to take judicial notice of the documents that have been filed recently where it demonstrates in a stipulation that what the current...
I'm just asking you, after the court issued the order, were the documents exchanged or not?
After the court I'm sorry.
After the court denied your objection to the magistrate's order, to the discovery magistrate's order, did you exchange documents?
No.
Thank you, counsel.
Thank you.
May it please the court. Jonathan Pickard from Quinn Emanuel on behalf of the plaintiff respondent CW Capital Cobalt.
So how are in the first instance, how are the documents material and necessary to the claims of your case?
Your Honor, as both the discovery master and Justice Maisley found, the documents are highly relevant. The reason why they concluded they are highly relevant is because what my client, as plaintiff, is alleging here is that its collateral manager, CWCI, the defendant, should have entered into a fee-sharing arrangement with its special servicer, CWCA. If CWCA refused, my client has alleged that they should have negotiated a fee-sharing arrangement with one of the other special servicers who exists in the marketplace as those agreements were available. What the documents are that are being sought here is the evidence of what fee-sharing agreements were available in the marketplace outside of CWCA. CWCA, the existing
What period of time?
Excuse me?
What's the period of time?
2011 to 2017. So Your Honor asked the question whether these documents are old, antiquated, stale. In fact, they are. They are all between 7 and 13 years old.
But I thought your adversary had a good response to the question was that the loans are long-term loans, so they may be old, but they're still relevant.
The only thing that they have put in their appellate papers, Your Honor, is that some of these agreements may still be extant. They have not put in any evidence of that. They didn't argue that below. In fact, there hasn't been a single factual affidavit that has been put in with any papers by any of the appellants here. All they have said is it's possible that one of these agreements still exists 7 years later. Based upon our knowledge of the market, that would be incredibly unlikely because it would mean that the same tranche of one of these CMBS securities is still the controlling party over 7 years. That's not how these deals work.
But that doesn't respond to the argument that the agreements are the same as they were. So, and they're still negotiating the same deal. I mean, we see contracts that are same for 20 years. So the fact that there are certain, it doesn't mean that they're not highly competitive. And I mean, and certainly you're getting your competitors' pricing information, which is pretty That's tough to do, and now you don't get it a lot. So this is not a nothing, right?
So, Justice Scarpula, there has been no evidence put in that pricing, in fact, has not changed. These types of structures have changed over time. There's only been lawyer argument. Maybe some of these agreements still exist, and maybe the terms are the same. Zero evidence
Either
in
way,
support of that.
you put in evidence that says it's all changed? No.
And we
So
are-
that's either way. But let me ask you a different question, which is, what about your CEO's statement? I can't unlearn what I will get from all my competitors' pricing information. Why would he say that?
There's a
And
good
why?
reason. Yes,
Why?
there's a
What?
good reason,
what
Your Honor.
possible How could that possibly help his cause?
It absolutely helped his cause. It wasn't my CEO. It was the defendant's counsel
Oh, I'm
who
sorry.
said that. It was the defendant's counsel, and the defendant's counsel said that because he was trying to suggest, yeah, there's no way for you to fashion a protective order that's going to protect this information so we wouldn't get the documents. And when he was actually asked the point-blank question, the protective order says, counsel, that you can only use documents
right. I'm
produced
sorry,
in this proceeding for purposes of this
but the
proceeding. He
argument
said,
really-
of course I'll comply.
Fair enough. But counsel began the argument concerned about confidentiality.
Yes.
And how do we meet those concerns, because they are legitimate concerns here?
And Your Honor, Magistrate Judge Gold, who is serving as the discovery master here, spent a tremendous amount of time focused on that very issue, and in fact has come up with revisions to the protective order to address this very specific situation. And what he has suggested is that, in fact, these agreements would be anonymized. The parties' names would be redacted from all of them. The trust names would be redacted from all of them, so that there, in fact, would be no way to look at these agreements, in addition to them being attorney's eyes only and having limited distribution. There'd be no way to look at the face of them and even know which counterparty entered into the particular agreements. So, in fact, what they have done is essentially turn these agreements purely into data regarding market practice, and that is it. And the judge also—
But critical data, right? Pricing and all that? I mean, so it is critical confidential data still in those documents.
Well, Your Honor, it is critical, highly relevant information for our claims that is at best dated. It is pricing information from 6 to 13 years ago that is going to be anonymized, that will be aggregated, used in an aggregated basis for purposes of the claims here. And it's simply, there have been great efforts undertaken in order to protect the interests here, of the respondents. And also, I would note, 4 of the respondents agreed to produce these documents subject to a different form of protective order. They actually agreed that they would produce them. So I think there's great question as to how concerned they truly are with the sanctity of this data.
Thank you, counsel.
A few points. First, let's talk about the protective order that was allegedly agreed to. It's either agreed to or it's not agreed to. And the actual facts are that there was a discussion between 4 of the servicers where if 2 particular terms were included in that agreement, then they would be in agreement with it. So that's what the story is there.
So respond to your adversary's point that it's been anonymized and there's no way to, the names have been redacted, so it contains just mere data at this point.
Just what, Your Honor?
Data.
I'm sorry, I didn't hear the
Data, that based on the redactions, all we have is data in there.
Well, but there's been no evidence that they have presented that they need a specific type of data that they don't already have.
No. I'm dealing with, because the premise of your argument is confidentiality. If all we have is data with all other relevant information redacted, is that sufficient to protect your clients?
Well, so that's what was not agreed to. I mean, the record is that there was an issue with respect to not allowing one or both of the parties who received the information to make redactions or to otherwise scrub the redactions, because then additional information would have to be provided. They didn't agree to that, and it's because that they didn't agree to that there wasn't actually an agreement on the protective order. Another point that I'd like to raise, if I could.
But that doesn't, but the protective order that was entered, correct? There was a protective order entered.
There was.
Right, that anonymizes the data, correct? That's my understanding.
I need to think about that.
Yeah, but I think, well, okay.
Well, you had another point you wanted to make? Go ahead.
Yeah, I do. So one of the things that I want to raise is I didn't hear at all in counsel's statements to the panel anything about how it is that they possibly need this information so desperately when their experts have already testified, when their experts have already put their reports together, when they originally filed a stipulation saying that they would be ready for trial, that there's no further discovery that needs to be taken. Now, I know that they filed an extension since that time, but they had represented earlier that they were ready for trial and it was ready to go. And here they haven't demonstrated at all how, even if they got this information, what would they do with it? What could they do with it? They couldn't. I mean, the expert reports are already done, so what is it going to be used for? And when you have the balancing, you had referenced the fact that there's got to be zero relevance. There has to be a balancing of the information that's requested, the type of information that's been requested, and the party's interests. And here, they actually have no interest whatsoever in it, given what the status of the case is right now. They've already done everything that they need to do with experts. How could they possibly argue then that there's any relevance whatsoever, given the fact that they haven't even demonstrated a reason for them to use it at this point in their case? It's one more point that demonstrates that this isn't at the beginning of discovery. This is at the end of the case when they're saying, yes, we're ready for trial. It's beyond a time when it could even be remotely usable. Why then would the burden be imposed on people who, my client, to have to produce these documents at a time when they can't need them, can't use them, they don't need them, and they're going to be disclosing them to a direct competitor?
Thank you, counsel.
Thank you.
Gowan versus Healy Nemeth. Whenever you're ready, counsel.
Nehemiah Glantz for defendants appellants. The crux of appellant's appeal and the crux of the motion below was that plaintiff's counsel repeatedly lied about the health status of Philippe Mastracci.
Are you suggesting there was no good faith basis for the representations made by the law firm here?
I beg your pardon?
Are you suggesting that there was not a good faith basis for the representations made by the law firm here?
Yes, I am saying that because first of all, there was never any examination or just
Did you request one? Did you
referee.
Did you request that he be examined?
We requested in the motion that he be examined, and the more important thing is, even if they thought that he did have cancer, whether he had or didn't, that's something. But the fact of the matter is that the referee came out with his order that the deposition has to be taken in France because of his ill health.
Well, wasn't there?
It came out in March.
Excuse me. Wasn't there the case was before the referee in February of 2018, and in January of 2018, and also prior to the referee's, the case being before the referee, wasn't there a doctor's note and emails referencing how the illness? And then the problem I guess you're having is that subsequent to that, when he took his deposition in October of 2019, and when he went to Vietnam in February of 2019, that other things came to light.
That's the real issue. The real issue is, first of all, the referee did not have a doctor's note at the time that he made his order. He repeated many times during conferences that he relied on the fact that plaintiff's attorney was an officer of the court. That doctor's note, which is, by the way, just a one-line note, it's not even sworn to, that came in the motion before Justice Branston when they did a 3104 motion about the referee's order. But as you were saying, the crux of the matter is that after the referee's order, the parties spent an enormous, a prodigious amount of time and expense drafting the Hague letter of request. There were many conferences as to what goes into this Hague letter of request because it required the contentions and defenses of each party. There were a lot of issues about how that's going to be drafted. And finally, we find out when the deposition happens in October of 2019, we find out in October of 2018, a year before, he had already gone into remission of his cancer. Not only did he go into remission.
I understand you focus a lot on the illness, and there's no question that the law firm, after October 2018, maybe were short on what they should have done. But ultimately, our 2019 decision, was it really predicated for reasons of health when we decided that the EBT would take place in France?
Well, that's two things. First of all, the referee's decision was definitely based...
Talk about our decision in 2019.
Your decision was also based on the health and also on a false narrative, that because Mastracci was an infant, 4 years old, when his grandfather passed away, how would he know anything about the painting at issue? Well, that turned out to be completely false, completely false. In fact, some of the facts that came out of the deposition are extraordinary. After the grandfather passed away in 1948, this was a close family. He lived with his mother, Renee, who passed away in 1973 when he was 29 years old. He lived with his mother, Maud, and she passed away in 1970 when he was 26 years old. And also his uncle, Jacques, who is Oscar Stetner's son and who never married. They also lived together, and he passed away in 1979.
You know, counsel, I want to go back because I don't recall seeing anything about the witness's health when this court affirmed, if anything, there were other reasons. The limited knowledge, excuse me, I'm still speaking. The limited knowledge, the fact that, let me see, he wasn't even born when the painting was confiscated, right? And he was a toddler at the time of his heir's death. I'm still speaking. I'm almost done though. I don't recall seeing anything in there about the health.
There were two things. First, I'm explaining about where the fact that he's a toddler, that turned out to be
but let's
false narrative.
Let's stick with my question, because my question just indicated health wasn't even a reason. It was the other three reasons, as I stated. So can we address that?
We can address that, Judge. Okay. Two other courts, the referee and the court below, based their decision on the health.
Well, hold on. I guess the question really is, when you got this decision and you realized that it was wrong from the appellate division, did you take any action? Was there any motion to be argued? Like that's really what the law of the case is now. That was our finding, right? And we based our finding on something other than the health. I understand that your position is that you're saying all of the things underlying at the referee and at the motion court were health related, but when we reviewed the record and made the decision, we based it on certain factors that aren't necessarily relevant to your argument at this point.
Right. And those factors that you based it on, the fact that he may have been a toddler, may not have known what was going on, that was a narrative that the plaintiff put forward as an additional reason to have the deposition in France. And that turned out to be false. He was very close with his uncle, his mother, and his grandma.
Well, but isn't that why we hold depositions?
I beg your pardon?
Isn't that why we hold depositions, to get that kind of information? I mean, obviously, this was before the deposition, based on statements that were made, but ultimately, it's...
Right, but how can an attorney say that his client has no knowledge, was just a toddler, has no knowledge about any of the issues here, when in fact he had plenty knowledge? His uncle, for example, was a Modigliani enthusiast
I'd like you to...
and a painter himself.
Counsel, can you hold the rest of your argument? You'll get more time on reply.
Please, the court. Philip Landrigan of Landrigan and Arnow for the respondent. I'm about to repeat Mr. Gowan's name. He passed away. We have a motion pending before the court to substitute Mr. Greason. So we have the Watson decision of this court that suggests that it's inefficient for this court to undermine the authority of the trial court, and inappropriate for you to substitute your discretion for the court. Now, that's a level of deference that has a practical basis in fact.
So you're not arguing that, you're not denying, you should have called your client and found out about the trip to Vietnam. You should have found out that he was traveling personally at the same time that you're telling the court that he's too ill to come to the U.S. for a deposition.
And
I mean, you're not saying that is the fact.
If in arguing to you that there's deference to the trial court,
Right.
The trial court found it was a close call.
Right.
I think under a standard of abuse of discretion, whether it's abuse of discretion, deference,
100%.
or de novo review.
So you're not denying the facts, you're just saying that we should leave the trial court alone because the trial court took all that into consideration and came up with a decision that is not an abuse of discretion.
Well, this is counsel.
I want to just ask you about that his knowledge that the uncle was a Modigliani. What knowledge? Where did that? Did he have any knowledge of the theft?
No.
Did he have any knowledge about what happened in 19?
Was his uncle, who is a
so you dispute that he had any real knowledge? This is all hearsay. People around him talking about what was going on during the time. Did he have any personal knowledge of the alleged theft of the painting?
No.
Okay, I say theft loosely, taking of the painting.
And counsel argues that there was a dependence on the medical record. Certainly the referee, the discussion is very informal. We weren't making motions. There weren't a medical record requested until a motion to appeal was made to Judge Branston, together with a motion to compel medical disclosure. And she said it's irrelevant. He's not a party. And I don't want to get into a debate about whether, this court has said he's not truly a non-party, and certainly he appeared for this deposition voluntarily in Paris. The letter of request procedure requires court proceedings that they didn't have to go forward because we consented to a commissioner. I came up with half a dozen alternatives, doing it by video. We can't take a sworn testimony in France.
Was that rejected? Video was rejected?
I can't hear you.
Was the request to take the deposition by video rejected?
Yes, and on the grounds that in France it could be a criminal violation. So I said, you know what, why don't we take it and we won't put them under, the witness under oath, and we'll have him read the transcript and sign an affidavit, which he could clearly do. So we bent over backwards to do this. And the idea that could we have done better is the question.
But all of those,
in hindsight, that's clear.
all of those things happened, I guess that what we're really dealing with here is like what was put before the referee in February of 2018. And was there any good faith for the representations made to the referee?
We made representations that Mr. Muski had cancer, and as a result of his chemotherapy, he had not, he had a heart condition. We initially had reported that it was a heart attack. That turned out to be inaccurate. We corrected that. And the referee, who's weighing not just the medical, the defendant never even asked for a medical record. There's an informal discussion with the referee. We gave him in good faith information. It's been substantiated. Mr. Mastracci has testified. His doctor submitted an order or a letter when it was appealed to Judge Branston. And he appeared and submitted an affidavit.
Yeah, but that's all fine, but really, after October 18, it seems to me that you did have some kind of obligation to verify the condition of the client, right?
Well, Your Honor, okay, so I'm in Paris preparing for a deposition that's going forward on October 2nd, and my client tells me that he went to Vietnam. If I had known, I would have disclosed that fact. When I found out, I was in a hotel room in Paris with a videographer and court reporters coming the next day, and there was no attempt to hide that information. I didn't. So the answer is, Your Honor, I would have, if I had known, I would have told them. And when I hear that,
And his deposition in Paris was October of 2019, and his Vietnam trip was February of 2019. So in that time, those 7 months, nothing ever came up with your, well, you don't have to tell me, but you understand where I'm going with that.
and again, this falls into the close call. Is it a close call? Could I have inquired more, or should I have? We were, nothing came up, and I wasn't making inquiries because we had the Gowan decision, and not just the referee, the trial judge, but this court had on the grounds of the limited knowledge that he's likely to have because of the points you made. He wasn't born when the Nazis sold this artwork, and he was a toddler when his grandfather, who suffered the persecutions of the Holocaust, died. And,
Thank you, counsel.
I don't get this. What's that?
Thank you.
You're welcome.
You may proceed, counsel.
If I could refer the court to the record on appeal, page 146. So on December 21st, 2018, this is 2 months after he'd got into remission, 2018, the referee asked plaintiff's counsel, what's the status of Mastracci's health? I want to know what the status is. They're still far away from actually going to France. What's the status of his health? Plaintiff's counsel answers, quote, Mastracci's health has not improved and he remains unavailable in New York for deposition. 2 months after he had gone into remission. He had already scheduled his trip, which was going to take place in less than 3 weeks in January 13. He does go January 13, 2019 to Vietnam on a 14, that's actually the shortest trip. It's actually an 18-hour-long trip one way. That's on January 13 for a 12-day pleasure trip with his wife. 5 days later, on January 30, 2019, we're in this court, in this well, arguing this issue about whether Mastracci is still sick. And plaintiff's counsel repeatedly represents to the court that he's still sick, that he's still unable to travel. So 5 days after he'd gone to Vietnam.
But here's the thing. I guess the question is, maybe they didn't ask. Maybe they should have inquired. Maybe they were, not active in their diligence in that. But where is the bad faith there?
Because there are so many cases that I bring down that when an attorney represents something about his client, how could plaintiff's counsel have made that statement that he's still ill and can't travel if he had not asked his client? All he had to do was pick up the phone and ask the client. There are a legion of cases where an attorney cannot just say things about his client without confirming, verifying it. There was no verification that his client was still sick. and he made the representation that he was still single.
Thank you, counsel. Thank you both. Bronxwood Home versus the AG of New York. You may proceed, counsel.
Good afternoon, and may it please this court. Anthony Radawatso on behalf of the Attorney General. The not-for-profit corporation law requires that courts perform a unique gatekeeping function in transactions involving the sale of a charity's real estate. In this role, courts are required to closely scrutinize the transaction to ensure that it will preserve charitable assets for public purposes and to protect the charity's beneficiaries against unwise bargains. Supreme Court abdicated this statutory responsibility by deferring to the parties and allowing Bronxwood to sell its real estate in a highly unusual bifurcated transaction that poses a grave threat to the charity.
So how have you shown, in fact, that this bifurcated transaction does pose really a great risk, you say, to the residents, the nursing home residents? How have you shown that here?
Certainly, Your Honor. And just let me add a little context here. Our office reviews about 20 transactions involving medical care facilities each year. Our counsel from the Charities Bureau is aware of just one transaction in the last several years involving a bifurcated transaction like this. And this poses severe risks for the residents of an elder care facility like the residents of Bronxwood here. This involves a charity divesting itself of its real estate, its most valuable asset. It's going to sell this to a private developer who's then going to turn around, mortgage that property, rent it back to the charity at a profit, and have the charity cover the mortgage payments. Here, the charity does not currently have a mortgage on this property. This is essentially—
Well, if the board of directors of the charity believes that this is a proper, good business judgment decision, is that sufficient, or should we scrutinize that?
That is not sufficient, and that is a critical error that the Supreme Court committed here. The parties in these types of transactions, they are not owed deference under the business judgment rule. Instead, the proper standard of review under Section 511, the court needs to ensure itself that the transaction will—
So what MBA did you put in? What evidence, other than lawyer argument, which I assume that the lawyers aren't MBAs, they're not business people, they don't know anything about this transaction special. What evidence from someone who looked at the transaction, a business person, who did you put in the record?
Certainly. Well, on the financial side of things, we're not saying we put on like an expert or something.
I'm just asking what you put in. Did you put in an affidavit? I didn't see a single affidavit. I didn't see a single financial analysis. All I saw was lawyer argument. Anything from anybody like an analyst or anybody who knows how to run a home for a nursing home, anything like that? Did you put anything in?
We did not, but I want to stress here that it is Bronxwood's burden to show the reasonableness of this transaction, and they have put no evidence to suggest that this is commercially reasonable here. And I do want to run through those financials real quick because there is actually evidence of this in the record. If you look at the appraisals, this is at pages 221 and 421 of the record, they actually show the operating income of this facility prior to this transaction. It historically operated with a net surplus. Now, in the two most recent years, under the W Group's management, it is operating at a significant loss.
This is post-COVID?
The fiscal year 2021 and 2022 are the most recent financial records that Bronxwood submitted in support of its petition. It is operating with a significant loss in those years, but what they also submitted in support of their petition are records showing that occupancy rates at the facility had returned to pre-COVID levels, so had revenues. So as they admit on appeal, their only rationale for this transaction was challenges posed by COVID-19. That no longer applies, and that did not apply at the time that this issue was presented before the court.
Counsel, it's my understanding that, if I read this correctly, that your office has a longstanding policy of requiring that a purchaser be licensed to do whatever it is that they would have to do before approving a real estate transaction related to that, and that the purchaser asked you to put aside that policy. Is that correct?
So due to the bifurcated nature of this deal here, there's this real estate transaction which this court is presented with. There is the separate asset purchase agreement, which is the business side, which is subject to DOH approval, and that is still pending, Your Honor.
Okay,
But
so
even
what is
though-
the basis for that policy that you don't approve one without the other?
That is not a policy of our office, Your Honor. We don't have just to make the record clear, we do not have a policy against bifurcated transactions if that's your question.
My question was not about bifurcated transactions, but transactions involving a sale of real estate where the purchaser doesn't have the proper licensing.
Well, that is up to DOH's discretion. DOH approval of that separate asset purchase agreement, we are not involved in that in any way. That is a completely independent review. And again, it has been 3 years here. That is, as my understanding, that's a long time.
So in your argument under 511, you're really concerned with the prong of the fair and reasonableness of the transaction, not necessarily the nature of the business being continued to serve the members.
It's both, Your Honor, and that's because Bronxwood does not dispute that this transaction will extract millions of dollars in revenues from critical elder care services each year. The rent alone is $1.3 million per year. This is a triple net lease, so that also includes costs, including property taxes, which is a new expense for Bronxwood. In addition, this transaction provides no contingency plan if that separate asset purchase agreement falls through. Bronxwood.
So counsel, yeah.
What does that mean?
So that means that the parties could be stuck. Bronxwood could be stuck in a perpetual leaseback agreement where they would be permanently divested of its real estate. They would owe rent permanently to the W Group in this transaction, where all of the power is in the W Group's hands, and Bronxwood is at its mercy.
So it's your position, I just want to make sure, because your position is that the Bronxwood didn't meet its burden, and that should be the end of the story, right?
That's correct.
Okay. What if Bronxwood took the money that it earned from the sale of the real estate, invested it in a Vanguard pretty large fund that's earning 20% interest this year, and made bazillions more than what they are required to put into this transaction, right? Do you know? That's what I'm saying. How do we know what is going to happen here?
Well, actually, Bronxwood has stated explicitly what is going
It's going to dissolve. I'm sorry, you're right, right?
They are getting out of the elder care business. Right. They plan to use this $16 million for 5 broad categories of grant making. They admit on appeal that the original charter controls how they can dispose of the assets from the proceeds. 0 cents will go toward elder care services. That is not allowed under their original charter. For this reason, we ask that this court reverse and deny the petition. Thank you.
Thank you, counsel. You may proceed.
May it please the court, Sean Shealy from Holland and Knight with my co-counsel Stanley Shine on the brief for respondent Bronxwood Home for the Aged. The Supreme Court got it right. The Supreme Court approved this real estate sale because 1, it's fair and reasonable, and 2, it promotes Bronxwood's
But your client
purposes.
is not, I'm sorry, the purchaser is not at this point licensed to operate this kind of facility, correct?
That's correct. The W
And it
Group,
may never get licensed to operate this facility, right?
that's correct. The W Group
So how
currently
does that
has
affect
28 facilities.
How does that affect the residents of this facility if they never get approved?
Yeah, there absolutely is an escape valve here. The Attorney General is incorrect. Under
So you
the
can
lease
sell it, and
agreement,
as I understood it, you could actually sell it to anybody after 5 years to use as they like, right?
no, if the W Group is not approved, we can get another buyer that is approved. We can assign the lease without the W Group's consent. That is in the record at page
But after 5 years, you
688.
could also assign it to somebody who can operate it or not, right?
Yeah, absolutely. The lease.
So in other words, 5 years from now, if the property is worth $1 gazillion, it can be turned into a condo development, correct?
The W Group has agreed under the
Just
lease
ask
that they
me,
will
is that
hold
a
it for
fair
5
statement?
years.
Counsel, is that a fair statement? 5 years from now, if there's no DOH approval, then it can be used for any purpose.
No, that's not correct. If there's no DOH approval, then we still are the operators of the facility. right? The W groups, so there's two transactions. The only one that's before the court is the sale of the real estate. And for that transaction, it doesn't depend
I
on.
think that that's the issue.
There's nothing
that
contingent.
That shouldn't be the only thing that's before the court. It should be together. There shouldn't be any bifurcation here. That's the issue, right? Isn't
The
that
Attorney
their position?
General has objected on two grounds to the transaction. One being the overall structure of bifurcation they complain about.
So then why don't you address that? Why is bifurcation in the interest of the clients of the nursing home?
Absolutely. It was necessitated by the Department of Health stopping reviewing any applications for new operators because of COVID.
Well, but that's changed now.
And that has changed now.
So
and the
now,
Supreme
what is
Court,
the rationale for the bifurcation?
That's exactly what the Supreme Court tried to get at and asked the Attorney General to get from the Department of Health. What's the status of the application? What is the timeline for the DOH
Your
review?
burden, not the AG's office. Your burden is to show that the bifurcation is good for the residents of the home. How have you shown that?
Absolutely. It's advantageous. It's the old adage, Your Honor, of a bird in the hand is better than two in the bush, right? The Bronxwood is going to receive $16
I'm not sure that's a
million.
principle of law, counsel.
Bronxwood is going to receive $16 million on the closing.
But
And
it
the
also
risk-
has to pay, it's currently paying you $1.9 million a year for management fees, and if it sells the property, there'll be lots of other fees it has to pay.
The Attorney General is incorrect there. Prior to the management agreement with the W Group, Bronxwood had another manager, and it paid that manager $1.4 million for its management
They also
services.
had a property that didn't have a mortgage on it.
The Bronxwood has always operated at a surplus, and in the prior years, it has donated $1 million to $1.5 million every year to charity. That's a surplus. That surplus that could be used, if needed, to pay for rent. Rent is also being misallocated here at $100,000 a month. It doesn't count under the triple net lease the savings for plant and maintenance fees, which are in the financial statements as $900,000 of savings. And taxes, Attorney General never raised that in the court below. It hasn't been preserved on appeal, and there's nothing in the record to say what the amount the taxes are, or why they wouldn't be covered under the operating
Would be
costs.
taxes? I mean, isn't that a pretty logical inference?
Under the lease, there would be taxes. That's absolutely right.
Which they now don't
but the
have to,
operating
which they
costs
now
are the
don't have,
limit.
excuse me, which they now don't have to pay, correct?
That's right. And the lease, the form of lease that we're talking about here, it's the DOH form. It contains very tenant-friendly provisions to protect the home. So the home, their financial obligations are capped. They are limited at the operating costs. So if the home isn't operating with sufficient costs, the landlord can't declare a default. These are not terms that you would find in any other commercial
So it
lease.
sounds like from what you're saying, okay, there can't be a default under that scenario.
That's right.
But certainly, how does that impact on the care and well-being of what it's charged to do is take care of elderly folks in the Bronx?
Yeah, the real estate transaction is totally separate. There's never been any issue about the
But it's
the
tied. See,
care
that's where
of the residents.
I don't know if I agree with you. I think they are tied together in terms of what the transaction is because of the bifurcated nature of the transaction that you have set up.
And especially in light of the fact that the W Group isn't authorized or to operate such a facility at this point, and they're waiting for DOH approval.
So the W Group took over as managers 3 years ago, and they have been managing the facility for the last 3 years. We still are the operators and hold the certificate, but they've been the managers for 3 years. The W Group.
I have another question. What about the appraisals that Bronxwood submitted? Because those appraisals indicate that Bronxwood, I believe, would operate at let's say, a positive operating income without the payments to the W Group. And right now, it was like 557 and change, a loss because of the 1.9 payments
The-
to the W
They're
Group?
COVID financials. They're not operating at a loss. Those are COVID financials that come in September 2022 is the last financials that includes a number of COVID months. The census is back up. The revenues are there. There's no concern about paying, and their obligations are capped if we get the lease to the operating funds from the facility. The appraisals are critical, though, because the only thing the court is asking to be approved is the real estate transaction, and the appraisals support. There's 3 separate appraisals that the
I'm
fair
still
market
troubled by
value.
that concept. It seems to me that since it's a not-for-profit selling off its assets, our concern is not with the half of the transaction you're putting in front of us, but with the welfare of the people who would be affected if your client in 5 years decides to turn the property into something else, which it has the right to do under the lease, as I understand. But I don't see how we can do our responsibility under the not-for-profit law by looking at half the transaction. It seems to me the not-for-profit law requires us to look at the whole transaction. What permits us to look at half of it?
It's not half of it.
What permits us to look at less than the whole?
The statute says all or substantially all is approved. The second part of the transaction will also have to come before the court or the attorney general. So it's not as if you're not looking at the whole thing. You're looking at the real estate transaction now, which gives the advantage of the charity
That's 95% of
getting
its assets.
it allows the charity to get
Yeah,
$16 million. There's not-for-profits change and sell their business to for-profits in the healthcare field all the time. That's not a problem. That's not something that doesn't make it fair and reasonable and doesn't make it consistent with its purpose. Here, the $16 million is going to be used to promote the mental health and well-being of the elderly, and that is consistent with its purpose.
That's where that money is going. But again, I think the concern, at least I am expressing, is the bifurcated nature of this transaction where you don't have DOH approval, and it's just like we're trying to predict what's going to happen in the next few years, and it's impossible in some ways, right?
Well, that's exactly why the uncertainty of the timing is critical to allow the bifurcated transaction. Because
Why do you
that
need a
allows you
bifurcated
to
transaction?
Keep the buyer.
Why not get approval, and then once you get approval, then you submit it as a single unitary transaction?
Because you have the risk of losing the buyer to the
Except
charity.
they weren't
The
looking
volunteer
for a buyer.
directors.
They weren't desperately looking for a buyer. They weren't looking at all. You approached them. So it might be a different situation if they had said, gee, we're in desperate situation, we need to get bought out. This looks like the best deal of the possibilities. But that wasn't the situation. Your client approached them.
I am the charity. The buyer approached
sorry.
me.
The buyer
approached my
yeah,
client.
I'm sorry. The buyer
approached our client.
Right.
During the middle of COVID, when these volunteer directors,
Right, but at that point, your client was not looking for a buyer, right?
they had looked in 2014 because of the rising costs of healthcare,
But at the
they were
time
not.
that the buyer approached them, they weren't actively looking, right?
That's correct. That's correct.
Thank you, counsel.
Thank you.
I have 3 very brief points, Your Honors. First, with regard to the protections for the elderly residents of this facility, the agreement lacks meaningful protections for these individuals. The agreement allows the W Group to transfer the real estate to a third party, to mortgage or leverage the property, which the W Group says it intends to do, to convert the property to a different use after 5 years. And 5 years is not a long time for these types of facilities.
Can I ask you a question?
Yes.
In March of 2021, when Bronxwood petitioned to amend their certificates of incorporation, and that was approved by DOH.
The amendment to the charter, yes.
Yes, right. What effect does that have on your argument right now? Because it was approved by DOH. It seems like that there's a path that's being...
Sorry, just to clarify, are you talking about the amendment to the charter?
Yes.
That was not approved by DOH, just to clarify. That was approved by Supreme Court in a separate proceeding, but that has no bearing.
They didn't object, I'm sorry, to the amendment.
That's correct. The Attorney General did not object, and we did not have a basis to object at that moment. Bronxwood had not submitted its petition before this court at that time.
No, but you seem to be saying that the only way that this nonprofit could fulfill its purpose is to run this nursing home. That can't possibly be right. It said the charitable purpose is to help aging people of a certain community. It's not to run this nursing home.
I would actually urge you to look at page 18 of the record where the original charter is. They are allowed, just to be clear, to give grants for certain purposes, but the charter makes clear that it has to be in connection to and to the ends of furthering the operation and maintenance of the facility itself. And Bronxwood has pointed to nothing in the
They've
record.
changed that now, right? They've amended that.
But they admit on appeal that the original charter applies here.
Okay, so
They
I
concede
guess what
this.
they could just do is reapply with the new charter and their new.
Well, they also concede that the quasi-cypre doctrine applies here, which requires them to use the property in line with the original donative intent, and they have not disputed that the original grant of this property was to be used for the operation and maintenance of an elder care facility.
So your position is it has to continue to be a nursing home, or it has to dissolve and go away?
Just to be clear, there are situations all the time where not-for-profit charities sell their real estate. They are in situations of dire financial need where they are trying to use the sale of the proceeds for substantially similar purposes. This is not a substantially similar purpose. This has nothing to do with the original charter of operating and maintaining an elder care facility. Just very briefly on the purposes that they've put forward for the bifurcated transaction, they've tried to rewrite history here. The only purpose that they put forward for this unique bifurcated structure is the W Group's financing for the deal, their soft loan. They now admit that the W Group has secured long-term financing for the deal. They're not subject to fluctuating interest rates. It will not expire. So there is zero rationale for this bifurcated transaction. If there are no further questions, I ask this court to reverse and deny. Thank you.
Thank you, counsel. Thank you both. People versus Bellamy. You may proceed, counsel.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of James Bellamy. From the time of his arrest in April 2013, Mr. Bellamy's case languished for over 5 years without proceeding even to hearings, let alone trial. The record makes very clear.
He was incarcerated at this time, correct?
Yes, he was.
So how much of that period was for other conduct, another conviction? How much for that five-year period?
He's detained pre-trial on this case for the first 4 years. Then he enters a guilty plea on the other case, and so the last year he is.
So you're saying 4 years on this, and then the last fifth was on the guilty plea.
The entire delay is cognizable under the constitutional speedy trial, even if he wasn't incarcerated at all. For purposes of the pretrial incarceration Taranovich factor, the time after which he is subject to a state sentence is obviously lessened. But the entire delay, even if he was already serving a sentence, which he wasn't, this entire time, this would still be an unjustifiable delay.
Well, counsel, I mean, we're gonna look at this case under Reagan, the 2023 case that the Court of Appeals decided, where there was this unreasonable delay. There we were dealing with pre-indictment issues. That's not necessarily the posture that the defendant was in here. The people had stated ready, and then there were certain things that delayed moving it forward. And I think a lot of the things, some of the things were co-defendants not being available, the people not being available, but also, in very large part, requests from the defendant for a new counsel, refusal to come to court. How do you reconcile that? Because I know that you allege over 1,000 days, but there were certain days where that, I mean, come on, if you look at the record.
Sure, Your Honor, I'd be happy to. So I'd respectfully disagree that it was in very large part, and I can go through that. It's true that Mr. Bellamy requested new counsel. We go through in our brief how much delay that caused, the amount of time requested by defense counsel to get up to speed on the case, because they do need some time. It amounts to about 4 months. The amount of time attributable to him not coming to court, on almost every occasion, his presence wasn't necessary and didn't delay things. There was one occasion where it delayed things at all, and it was by a week. So there's certainly delays attributable to Mr. Bellamy. they just pale in comparison to the much longer periods of delay that are attributable to the prosecution's failure to answer motions, failure to appear, and, as you alluded to, the failure of co-defendants' attorneys to be ready. And under Wiggins, it's quite clear that the prosecution can't just sit by and allow a case to languish because the other defendants' attorneys aren't present. They have an obligation to keep the case moving and to make sure it actually gets to trial in a timely fashion. If you look at their response to the 3030 motion below, obviously that's not before you on appeal, you'll notice that a huge amount of time, they say, is attributable to the conduct of co-defendants' attorneys. And the reason they said that in the 3030 motion was because they knew they could get that excluded under 3030. But then when the constitutional speedy trial motion comes around, suddenly they're trying to blame it all on Mr. Bellamy. The record just doesn't bear that out. You can look at this record, and it's just very clear that a very small amount of the time was attributable to either Mr. Bellamy or his attorney.
Oh, but weren't there times that he refused to appear? There were years of negotiations, right? You kept declining the offers. I mean, so there was a combination of factors that resulted in this.
Respectfully, Your Honor, again, his refusals to appear on almost every occasion where that happened, it didn't delay things at all because his presence wasn't necessary because there was some other reason they couldn't move forward. And the one time it delayed things, it was by a week. That was in September 2017. One appearance by a week.
Counsel, are you saying he changed lawyers 4 times? You're saying that all 4 lawyers altogether only cost 4 months?
Yes, Your Honor. We lay it out in our brief, and I can explain that. On one occasion, for example, it's because before the change of counsel happened, the case had already been adjourned for 3 months for reasons having to do with nothing to do with Mr. Bellamy. So he had some sort of time built in, but it's pretty clear Mr. Bellamy didn't cause that delay. The co-defendant caused that delay. But, I mean, you can look at the time that's actually requested and what time people say they need. I mean, I don't think there's any basis for this court not to take Mr. Bellamy's attorneys at their word for what time they needed to get up to speed on the case. And the amount of time that they asked for only amounts to about 4 months. And then there's a few other months where they don't appear, about another 3. Again, we lay this out on pages 22 and 23 of our brief. So we're talking about 7 months of delay caused by Mr. Bellamy or his attorneys. If you want to round that up even to a year, it still pales in comparison to the many years of delay. I also just want to briefly address plea negotiations. There's no indication in the record that plea negotiations were ongoing for years. There are about 2 months that the parties indicate are devoted to plea negotiations, and at that time, the people indicate that it is sort of the beginning of plea negotiations, and that wraps up within a couple months.
Thank you, counsel.
Thank you.
You may proceed.
Good afternoon, Noah J. Sexton for the people. I just want to begin by giving full context as to how Mr. Bellamy contributed to these delays. So he requested 4 new attorneys, grievanced the attorneys each time after he fired them.
And how much time did that?
So our reading of the record, which obviously we disagree, is that not just, oh, this is when we wanted to adjourn to, the delays that were the result of the chaos that happened when he kept replacing attorneys was well over a year on its own.
Yeah, but this is 5 years that we're so what happened all of the rest of the time?
Well, initially, as you pointed out, he refused to be produced 7 times, even fighting a force order to produce, and it did happen once on the eve of trial. But I'll move away from that. What further complicates things, which made the entire process of getting him to court, getting this investigation done, is the fact that he was indicted twice while this is going on. One of the indictments was for plotting with an undercover officer posing as a hitman to murder the victim in this case. And so at that point, everything had to take a hold. We had to go look into, okay, what is going on here? There was an active investigation happening while we were moving through this.
I guess I'm wondering, when the people state that they're ready, they have an obligation to continuously be ready or they get charged, right?
Correct.
And there were times when the people weren't ready. So even if we're talking about this investigation that's not going on, the people are not ready, but you're saying that you're not ready based upon these excludable reasons? I don't...
And I will say, to clarify, I'm not saying that the people are totally blameless in this situation. Obviously, the delays, there are some delays that were attributable to us. I think, though, that under the Taranovich framework, we're looking at the whole situation. Even with what we contributed to the delay, none of this rose to the level of a constitutional violation. It's a very different calculation than, strict 30-30.
Well, extent of the delay is 5 years?
The delay is approximately 5 years.
And then the reason for the delay, you say mostly it's the defendant's fault?
We would, yes, in significant part it is the defendant's fault. Not all of it, because obviously as we conceded in motion practice below,
So how much of it would you attribute to his being indicted for conspiring to arrange the death of one of the witnesses in this case?
we didn't put an exact number on it. We essentially just, in our overall assessment of the situation, showed how this complicated things incredibly, if that makes any sense. It's hard to quantify.
Was it a year, 2 years? I mean,
Well, it ultimately
how
took...
long did the investigation take?
So the investigation was over the course of a few months. What had ended up happening, and this is discussed in the next brief, but what ended up happening is that he contacted an undercover officer, and it was an ongoing kind of thing for a few months until eventually he was caught after payment was rendered.
Anything about the nature of the underlying charge?
Well, that's the other thing about this, and Factor 3 really, in a way, speaks most to the people's case, most favorably to the people. This was a complicated crime. While gang assaults, unfortunately, are not necessarily uncommon in the Bronx, this was a 5 co-defendant case that started at a nightclub, moved to another residence. Every person played a different part of varying severity throughout. Co-defendant Duperoy and this defendant, they, for example, played very violent roles in this crime where, Rivera and Garcia and Little, they didn't really do anything violent. So it creates a situation where we have varying roles for each of these participants, various levels of culpability, but the evidence is largely the same. And so we have to parse through everything that happened and try to figure out who goes where before we can do anything.
How many years does that go on? I understand, can't look at it in a vacuum, but do you quantify it in any way?
Felony cases, I didn't find one definitive number, but the OCA has stated that felony cases do often take well over a year.
We're talking about 5 years. And so, I know that we're looking under Taranovich, and it is cumulative. It is 5 different things in this and you have to look at each separate thing. You have to look at each thing and maybe, combined. I guess the concern is that just because this is a complicated case, just because the defendant at times refused to come to court or changed counsel, even taking all of that, this delay was just unconstitutional, was unreasonable.
And I understand that on its face, it is very shocking. I mean, when you first look at it, there is a certain level of sticker shock, I suppose. But keeping in mind how egregious defendant's behavior was and how constantly he confounded his own investigations and the court by grievancing attorneys, firing attorneys, refusing to come, committing new crimes, to say that now, because of that delay that was based in no small part on defendant's bad actions, that he should be allowed to claim that he was denied his own rights by his own bad behavior.
Let me just ask you, did defendant ask for severance from the co-defendant here?
It was discussed. It was not particularly moved as far as I recall.
So it's also some of it was co-defendant.
So if you don't mind me making this point to answer your question, in Wiggins, which is what defendant is relying upon by saying that the co-defendant delays are attributable to the people, and it seems that his position is that all of those delays can be attributed to the people and that they speak totally against us. Wiggins is distinguishable from this case. When you look at Wiggins, we're dealing with a defendant who was actively engaging in dilatory tactics, and that the people were not just acquiescing, they were playing into what he was doing. That his co-defendant was saying, oh, I am interested in entering into a cooperation agreement with the people. Okay, the people keep trying to pursue that. It quickly becomes clear that this is just that co-defendant playing chicken, and that he's not serious about entering into this cooperation agreement. The issue in Wiggins was that the people kept pursuing it. And in the interest of essentially just furthering a delay tactic for this co-defendant that was not necessary by any means, they deprived the defendant in Wiggins himself, of his constitutional right to a speedy trial. That's not happening here. There's no indication that any of the co-defendants were trying to engage in any dilatory tactics. They just simply, there were a lot of co-defendants who participated in this one crime.
And in Wiggins, there was a motion to sever, wasn't there?
There was a motion to sever in Wiggins, but really our big distinguishing factor that we have thought about is the fact that there were no dilatory tactics like the ones in Wiggins here. There just weren't. And so while, yes, we can't blame defendant for, all the delays his co-defendants had, same token, you can't turn and say, and that was the people's fault for not immediately severing when there were, a bunch of scheduling conflicts. We didn't have a need to sever. We didn't want to sever. Unless your honors have any other questions, I'll leave the remainder of my argument to the papers.
Thank you, counsel.
Just very briefly, Your Honors, I think something that's important to note is a lack of detail in respondents' arguments about what time we're actually talking about. They're trying to address this at a very high level because they know if you actually drill down into what caused what amount of delay, it doesn't look good for them. Mr. Bellamy's pending indictment, I want to make note of the fact that at no point in the proceedings below, either contemporaneously or in response to the constitutional for speedy trial motion, did the prosecution ever claim they needed more time because of that indictment. That's simply completely absent from the record. It's been evented on appeal. With respect to the contention that this is a complicated offense, it's certainly an extremely serious offense. We're not going to downplay that at all. It wasn't complicated. The prosecution had essentially all the evidence they were going to get right from the start, and they answered ready for trial before Mr. Bellamy was even arraigned on the indictment. And again, they never once said they needed more time to investigate. Not once. And in their response to the constitutional speedy trial motion below, they never claimed that any portion of the delay was due to the need to investigate or the supposedly complicated nature of this offense. It's just not in the record. And finally, I just want to touch base on what respondents said about Wiggins. Wiggins is pretty clear that it's the prosecution's responsibility to move the case forward to trial. This idea that it only counts against the prosecution if the co-defendants intentionally try to delay, that's not Wiggins. And this is because the baseline rule in constitutional speedy trial is that all delay, except that caused by the defendant, counts against the prosecution. It counts to differing degrees depending on how intentional it is, but all the delay counts because it's not like 30-30 where you just have to be ready whether or not the case actually goes. It's a responsibility to actually take the case to trial. They didn't do that here. They didn't even come close to doing it. They didn't show any urgency in doing it. And 5 years is much, much too long with no explanation. You're due to reverse. Thank you.
Thank you, counsel.
Sorry, are we arguing the
Thank you. We're done. Yeah.
We're good? Great. Thank you.
Meljek.
The court's permission, we're all appellants, so does it matter where we sit?
Sit on one side. Don't confuse me. Okay, you have your 3 minutes, counsel.
Glenn Dolan with Morgan Levine Dolan for the plaintiff appellant respondent. Plaintiff's appeal arises out of a high-low settlement agreement between the plaintiff and one of two defendants, West 70th Owners Corp., that was placed on the record during trial. Pursuant to the terms of the settlement, if the jury were to award a verdict against West 70th Owners of anything from a defendant's verdict to an amount, from a defendant's verdict to a verdict of
We've
$1
read
million.
the transcript.
Yes, sir.
Why shouldn't who put the appeal or the settlement on the record?
The plaintiff's
So
attorney
if
put
there's
the
an
settlement on the record.
ambiguity, why shouldn't it be held against the plaintiff's attorney?
I would submit that there is no ambiguity, that just because the
You have two other defendants, two live defendants, real issue as to what apportionment between the three defendants is going to be. Wouldn't it be incumbent on the plaintiff to say whether or not apportionment is part of the high-low?
No, Your Honor, because apportionment is never a part of a finding on Labor Law 240 and Labor Law.
We're talking about the settlement agreement. It's a settlement agreement, right?
The settlement agreement is triggered by the verdict, and the exact wording of what was put on the record was a verdict, a defendant's verdict or a verdict up to $1 million. The verdict against West 70th Owners was threefold, right? They were responsible under Labor Law 240 because they directed and controlled the work. They were responsible under Labor Law 241-6, and the owner was responsible under 200. And I agree with the court. Under Section 200, the defendant, the owner, gets the benefit of the apportionment of a fault. But under sections 240 and 241.6, a defendant never gets the benefit of apportionment. It is joint and several liability.
So you're saying under 1601, does 1601 exclude labor law cases?
1602 subsection 8 excludes labor law cases. It says everything under Article 10 is excluded. Labor Law 240 and Labor Law 241.6 are in Article 10 of the labor law.
And then how do you distinguish Batista?
Excuse me?
Batista, how do you distinguish Batista?
I'm sorry, I don't.
How do you distinguish Batista?
I don't know the ruling of Batista, Your Honor. I apologize.
Okay, fair enough.
But if you, I'd be happy to address it if you just give me.
If you haven't read it, there's nothing to address. Anything else, counsel?
Let me see. No, Your Honor, I have nothing further on that.
Okay. Thank you.
Good afternoon, Your Honors. Scott Quirnbaum. I'm appellate counsel to Callahan and Fusco, and with me is Christopher Delbove, who co-wrote the brief with me. I want to start with what I consider the big issue in this, and that is the evidentiary errors and the instructions as they concern and solely concern, or not solely, primarily concern, the issue of new orders liability as the alleged general contractor. Just so we're clear, because plaintiff's counsel sort of conflated some issues, there was the issue as to whether New Order was the general contractor or not was hotly contested. There was sufficient, if you believed plaintiff's testimony, they were the general contractor. If you believed New Order's testimony, they were not the general contractor.
And what about the work orders and making reference to the PSA?
Certainly. I'm grouping that within plaintiff's, I should have said plaintiff's evidence. That's certainly part of plaintiff's. Absolutely. If jury credits that, then they would find the general contractor. But in the context of the defendant's case, as we argue, the trial court, to us, inexplicably, given the state of the law, excluded emails between Abrams, who was the principal of West 70th, and I always screw up his name, Spitalnik, who was I believe it was, if my memory serves, the engineer, that in which he specifically says, we would be hiring the contractors. That's the November 30th, 2012 email. This is post-incident, which the trial court hung its hat on, which is not the law. And then on December 1st, Abrams writes, to Spitalnik, you had the actual contract from New Order. It details exactly their scope of work, which did not say anything regarding supervising and hiring subcontractors, which is one of the...
So, counsel, but there was testimony about the emails, right? And there was cross-examination on the emails, correct?
Not really, Judge. And if you...
No, not really. Yes, there was cross-examination. Not a single question of cross-examination on the emails, even though they weren't read into evidence?
No, in fact, as we point out in our brief, right, if I can, in our reply brief, no, if you look at, no, they weren't. They were dealing with sometimes they were dealing with earlier emails. In fact, at one point, New Order's trial counsel, Mr. Brill, tried to refresh Spitalnik's recollection with one of these emails, and the trial court shut it down right away.
Well, counsel, why wouldn't that be harmless error? And why wouldn't that also, it seems like the issue of the general contractor really came down to, even if you include those emails, a matter of credibility, which the jury was free to either accept or reject.
Well, but it went straight to its defense. When you have, it directly contradicted Abrams's testimony, saying that, no, they were that we hired them to be the general contractor, and here you have him admitting that he's doing the hiring of subcontractors, and it says, and that the contract said nothing about New Order hiring and supervising subcontractors, which is one of the quintessential functions of a general contractor. But it's not just the emails. There's also the jury instructions. You know, just so we're clear, we are not arguing on appeal that it was error to admit the the Department of Building Permits. That was argued below, right? That was clearly relevant evidence that supported plaintiff's West 70th's claim, but not to give the instruction which plaintiff's counsel, West 70 is not participating, which plaintiff's counsel agreed was an accurate statement of the law, tied New Order's hands.
Did you put the charge conference in, the record
No,
of the charge conference? Did you
charge
put the proposed
Yes.
charge in?
Yes, the proposed charge can be found at, I have it. At
So how do we know?
395, 396, because,
How do you know, how do we know what the trial, why the trial court didn't charge it if you didn't put the charge conference in?
I can't answer that.
So how can we review it on appeal?
Because-
If you didn't put the charge conference, we have no idea why the trial court did that.
But, no, I'm sorry, the charge conference is not in, but the charge is in.
No, but the transcript of the trial, of the charge conference would tell us why the trial court didn't accept that charge, right?
Presumably, all right?
Okay.
I
I don't know how we could review it without
Because-
knowing why the trial court didn't do it.
I'll tell you why, Judge. Because this is so clearly error. Right? Because, no, just think about it, Judge. If you put in these Department of Building permits, right, and the law is, just so we know, the argument was presented, and the law is that they're evidence, right, but not dispositive. I'm paraphrasing, but that's a correct statement of the law. And then the argument gets made, and then what can New Orders Counsel do about this evidence? They can't say anything because there's no instruction to back it up. And I will say, even if you're correct, Judge, I submit that the emails by themselves are reversible error. They're not harmless. Right?
Did the trial court let no emails in?
No, none of the...
None. None of the post...
He didn't allow any of the post-incident emails
But
in.
pre-incident emails, there was.
Yes.
So there was evidence in the record with respect to that issue.
But it was not as clear-cut.
Okay, but so your argument is this wasn't cumulative. There was evidence. You're just saying the evidence that the trial court excluded, which was post-incident emails, was not as good as what you wanted to put in.
That's not what I'm saying, Judge. It's not nearly as clear.
Okay.
It was touched upon. I see my time is up.
Thank you,
2
Counsel.
minutes for rebuttal.
You will get a chance on rebuttal.
May it please the court, Glenn Kaminsky with the firm Morrow, Lilling, the party counsel for Bronx Excavation. I'm loath to believe that you even want to hear from me or need to hear from me on this case, so I will keep it brief. Neither of the appeals directed to Bronx Excavation. The owner is not and could not appeal. All claims against Bronx have been dismissed, and the court severed the third-party action. There's no reason at all that Bronx Excavation has any further involvement if there is a further trial. Unless this court has actual questions for me, we're happy to rest on the record and brief.
Thank you, Counsel.
Thank you.
Okay, you reserve 5 minutes. Go ahead.
I actually thought the first part would be far easier. Okay, responding to New Order's cross appeal. It's not only the transcript of the charge conference that was not submitted by New Order in its underlying motion. New Order also failed to include the plaintiff's entire first day of testimony, all of West 70th.
Let me just interrupt you for a moment, please. May I just ask you, is the proposed charge, I didn't see the proposed charge. Is it in?
Their request to charge is not in the record. There was
So what's 395, 396 of the record?
email that defense counsel sent to plaintiff's
Okay.
counsel that includes one proposed charge within the email. The court was CC'd on the email with regard to the permits. That's it. Their request to charge is not in the record.
And there was a formal request to charge, as, I mean, when I was a trial judge, that's how I did it.
All
right?
parties submitted a
So
formal.
that would have been a document that said, here's what I want you to charge, right?
All parties submitted a
And
formal.
that's not
request to
in.
charge. That is not in the record.
What about this issue of the post-incident emails?
Sure. So addressing the post-incident emails, if you look at the supplemental record, page 39, those post-incident emails actually state that New Order was the appointed general contractor. Those actually support the plaintiff and the defendant owner's allegations, not New Order's allegations. In addition, defense counsel alleges that those post-incident emails are important because they say that the owner hired the contractors. That was never debated at this trial. In fact, the owner testified at pages 1,594 through 1,595 that he hired the contractors. He hired the general contractor, New Order, and he hired the subcontractor, Bronx Excavation.
I guess their position maybe is that normally in labor law cases, the GC would hire the subcontractors, and that's just not the role that they were playing. And even in some of the work orders, they were paid for certain work.
Absolutely, hiring subcontractor is a indicia, but is not the only indicia of being a general contractor. The main indicia of being a general contractor is the ability to supervise and control the work of the contractor, the subcontractors, and in this case, the testimony of the building owner was that New Order Construction had the authority to control the means and methods of the work of all the subcontractors on site, including the plaintiff's employer. In addition,
Does it matter that the plaintiff testified that the owner controlled his work how the incident happened?
it matters to the extent that that is the basis for the owner's liability, right? For an owner to be responsible, here it's being converted into a single-family home. So in order for the plaintiff to hold the owner responsible, this is the first question on the verdict sheet, the plaintiff had to establish that the owner controlled the injury-producing work. He was there at the time, standing over the plaintiff, telling the plaintiff what to do. That was the plaintiff's testimony, and that is what the jury believed.
But under other parts of the labor law, that doesn't really matter when you're talking about the general contractor.
No, it doesn't. You're absolutely right, Your Honor, because to be a general contractor, you don't have to be there controlling the work. You need only have the authority to control the work.
Are you talking about the 200 negligence claims, or are you just talking generally about?
I'm talking about
I want to
labor law.
get specific onto the 200 negligence claims as well.
I'm talking about 240 and 241.6. That's an excellent clarification, Your Honor. So under 240 and 241.6, to be a general contractor, you need only have authority to control the work, to implement safety measures at site, and there was testimony to all of that by the owner.
So then why don't you address New Order's liability with respect to the 200 and the negligence claims?
Sure.
Where this is means and methods, correct? We agree it's means and methods, where there has to be an actual exercise of authority and control over the work plaintiffs perform.
So I will concede that I believe that is New Order's strongest argument in its appeal, its attack on the Labor Law 200 claim. Labor Law 200, as the court well knows, requires the general contractor to construct, equip, arrange, operate, conduct the work site to provide reasonable and adequate protection. There is no testimony that the general contractor was physically present at the moment of the accident. And that is the basis why New Order is maintaining that it cannot be held responsible under 200. There's a little bit of a distinction here, however. New Order dug so this is an excavation in a basement in a brownstone in Manhattan. The owner wants a built-in pool in his basement. So New Order Construction digs that hole. The general contractor digs that hole down to bedrock. They run into trouble. Bedrock is obviously hard. They say, you know what? You're going to need a specialist for this. We recommend you hire Bronx Excavation. And then the owner does hire Bronx Excavation. But it's New Order that dug the hole down to bedrock. And when that excavation collapsed, it wasn't the bedrock that collapsed. It was the loose soil that New Order itself dug that wasn't sheeted, shored, or braced in any way. That's the basis of the plaintiff's claim that New Order is responsible under Labor Law 200. I recognize it's a very strong argument on defense counsel's part.
Thank you. You have another
I
question?
just want to ask you one question about the apportionment issue.
Sure.
So the court directs liability for, on 241 and 241-6, right?
Not exactly. I apologize if I'm interrupting.
Yeah.
It's okay to speak?
Did it go to the jury? Did liability under
Okay, so
241 or
the court found as a matter of law there was a violation of 240 and 241-6, but did not direct liability against the general contractor or the owner. That was for the jury to determine whether the owner falls within the exemption to the homeowner's exception, they were directing and controlling the work, and whether New Order was in fact
But
a
there
general
wouldn't be any apportionment against the owner under 241, right?
No.
So then where is it that, well, how is it that you're saying that you get the benefit? If you wanted that, you should have said something, but all you say is, we're gonna do a high-low, and the only thing the jury is deciding on damages is 200, right? And apportioning liability is 200, not 241-6, and not 240. So you, as the party who are doing the high-low, if that's where you wanted to go, you should have said, doesn't matter, the apportionment doesn't matter, but you didn't say
No,
that.
this is why I respectfully disagree. When the case went to the jury, the owner had not been found responsible under 240 yet. We had to prove that they qualified under the exemption to the homeowner's exception to 240. We had to prove that the homeowner was standing over the
But you're
plaintiff.
talking about apportionment, not proving the liability. You're saying that you shouldn't, that we shouldn't assume that there was, that the high-low included apportionment. But what I am saying to you is the jury verdict on apportionment only had to do with Labor Law 200. And if you wanted it to be different, you should have said that in your stipulation.
I agree with that, but if you look at, I agree that apportionment only applies to 200.
And that's all the jury did, and
No.
you're talking about a high-low. Now, I'm not talking about apportionment of damages. I'm not talking about liability as to whether or not the homeowner exemption applies. I'm only talking about apportionment of damages, right? There was nothing about that in 240 or 241-6.
Agree, but here's where I respectfully disagree with the analysis. So the jury had to make a finding. It was question number 1 on the verdict sheet. Did the owner direct and control the plaintiff's work at the time of the accident? If they answered no to that, plaintiff loses under 240. And then the defendant does get the benefit of apportionment. But because the plaintiff prevailed on that question, the defendant does not get the benefit of apportionment.
But I'm saying to you that that's not what your that's not what your high-low says. Your high-low says something else.
I disagree because the high-low says verdict. The high-low says if the jury awards a verdict. It doesn't say if the jury awards money damages in this amount. It says if the jury awards a verdict. And the verdict in this case had 3 components. Were they responsible under 240? Were they responsible under 241-6? And were they responsible under 200?
And they found all 3, right?
Yes.
So how is it that you get the benefit? You don't get the benefit. You're saying we should only look at the 241 part of that verdict and not the 200 part of that verdict.
Because the plaintiff won 240 and 241. If the plaintiff had lost on 240 and 241 and only won under 200, then I agree with the court's analysis. Then the defendant would get the benefit of the apportionment of fault. But why did we even bother submitting it to the jury on 240 or 241-6 if we weren't going for joint and several liability? We were. And all the attorneys in the courtroom were fully aware of that when they entered into that agreement.
Thank you, counsel.
Thank you for your time.
New order, 2 minutes.
Wish I had divided the time as Judge, first things first. On the issue of the request to charge, it's in the record. If you look at page 394 of the joint record.
I looked at that. That's not the requested charge.
Sure it
It's
is.
a transcript concerning the requested charge.
No. It's a reference to.
It's a reference to, but it is not the requested charge.
Sure it is. See, look at 115 of the supplemental record.
The supplemental record.
See, it was not originally included in the joint record because plaintiff's counsel, who compiled it and did an otherwise fabulous job, failed to include the hyperlinks, the references, which under CPLR 2214.
Wait a minute, the supplemental record is only 138 pages long, and you told me to look at page 394.
No, 115. Oh, no. The record, the joint record, The record on appeal at 394 is Mr. Brill's affirmation, which references the
Right, but what you were being asked are the proposed jury instructions in the record? And you said yes. I don't think that's correct. I've looked.
So if
That's
you look
one of the reasons I have this up here. I don't see the proposed jury instructions. I see references to them in various pieces of transcript, but am I correct that the document titled proposed jury instructions is not in the record?
I believe, but at supplemental record 115, there is an email from Mr. Brill.
An email's not what I'm asking about.
Why does he's giving a specific, he emails the judge, the judge is on the email, and it says, please give the following instruction.
Right, but the entire document, the proposed jury
It's
instructions.
a supplemental request, Judge. There is an initial request to charge, right, which does not include the general contractor and DOB. Then there's a supplemental request that's contained in that's referenced in the record on appeal at page 394. Okay, and then which refers to document number NYS CEF Doc 64, which under CPLR 2214C suffices. Right? And then that gets, and then if you look at the supplemental record at 150.
I see that, but
Okay.
it is not the entire document of your request to charge, right?
No, but I'm just talking about the general contractor and the DOB request to charge, okay? As far as back to the emails, what the emails mean for the jury to decide. This court has repeatedly said, you know, it is for the jury to when there's differing interpretations available as far as what emails mean, that's for the jury. One last point with respect to Bronx excavation. The court couldn't have been clearer that the dismissal against New Order was without prejudice, and it says, the trial court made clear, it says, it granted that part of New Order's motion to the limited extent of, quote, setting aside the apportionment of fault as to all parties, and the action shall be retried on the issue of apportionment of fault only. So when regardless of how the court rules, and hopefully we're going back to trial on all issues, but if not, there will be a retrial that involves Bronx excavation and that involves New Order and that involves the homeowner on far as apportionment of fault. Thank you very much.
Thank you all. Wesco Insurance. You may proceed, counsel.
Good afternoon, Your Honors. Joshua Abraham for the defendant appellant, Delco. The central question before the panel is the classification limitation endorsement in the parties' agreement a policy exclusion? The definition of a policy exclusion based on the precedents of this court and the Court of Appeals is, does it modify existing coverage in an insurance contract?
Well, does it modify it, or does it define what the scope of coverage is?
Your Honor, the actual provision at page 175 in the record says, quote, this endorsement changes the policy. It also says this endorsement modifies insurance. Under this court's precedents, the court has to take into account and give effect to that language. The interpretation of the court below and of my adversary does not give effect to that modification language. In fact, Your Honor, this modification language, this provision, was pointed to by the insurance company when they changed their mind over a year later after agreeing to defend and indemnify my client in a litigation. They sent a series of letters. They proposed a series of excuses. Finally, in their third letter, they settled on this classification limitation endorsement. It says that it changes and it modifies the policy. That is the very definition of an endorsement under the precedents of this court.
But couldn't it also just, I mean, to give it effect that they used to cover this and now they're not covering it anymore? That's the whole, but that's not an exclusion.
That is an exclusion.
That is, no. It's the policy, because they're not going to give you a whole new policy because you've had this policy for 100 years, right?
10 years, Your Honor.
They're not going to redo the policy. They're just going to say, here's not what we're not covering. This this new policy doesn't cover this, this, and this, and that's why the policy is changed. That is an exclusion, and that gives meaning to those words.
Exactly, Your Honor. If that is an exclusion,
No, I'm sorry. No. That is that means there's no coverage. Not that it's covered except for this part of it. It means it's not covered. And that we have a case that says that exact language means no coverage.
that is the Black Bull case, Your Honor.
Right.
And if I could use a little bit of humor, Black Bull is a red herring. It has absolutely no bearing on this case.
Really? It doesn't deal with the same categories?
No, it deals with different categories. It's distinguishable, completely distinguishable for three separate reasons. The first reason, Your Honor, is in Black Bull, the court did not deal with modification language that's explicitly in a CLE, a classification limitation endorsement. That wasn't before the court, that wasn't briefed, that wasn't argued. The court was dealing with a very different issue. The second reason that case is not distinguishable is because these classification limitation endorsements, they're inserted regularly now in all insurance policies. They get inserted all the time. And Black Bull did not say, as a matter of law, that every single classification limitation endorsement is not a policy exclusion. It doesn't say that. That's a very expansive view of that case. And if that idea is followed by this court, that would mean that insurance companies could avoid all exclusions by simply inserting something called a classification limitation endorsement. That can't possibly be the law, especially a provision that says that it changes and modifies coverage. The third reason it's not applicable is because in Black Bull, the subcontractor in that case was engaging in demolition work. The policy, the classification page, the original classification page, never even had demolition work to begin with. It was never covered to begin with. So then later on, when they say that this provision's an exclusion and the court says it's not excluding anything, the reason the court is saying that is because the classification page to begin with never had demolition. In this case, the issue is that the subcontractor was engaging in carpentry work.
Which is listed.
Which is listed, exactly. It's absolutely listed. Then comes this provision and says, all right, we're changing the policy. We're modifying the policy. If it's performed by someone other than the named insured, you're no longer covered. That is the very definition of an exclusion, to Judge Scarpagula's point. That's why this is, in plain English, we respectfully submit, this is an exclusion, and therefore insurance law 3420 applies. It's a year late. I reserve time for.
Thank you.
Good afternoon. Max Gershwire for the respondent. Black Bull is on all fours.
But address the point, the modification that we need to give effect, obviously, to all parts of the policy. Address the point with respect to modification.
Sure. Every endorsement, an insurance policy contains base forms and endorsements, just like this policy. Every endorsement to an insurance policy, you can look at your own, your homeowner's policy, says this endorsement changes the policy because it's not the base coverage form. So in other words, and in Black Bull, by the way.
So why is that not an exclusion as opposed to a non-coverage issue? Right? That's what that is, why have we decided that that's, because there are other people who are covered under this piece of the insurance, except if you're doing work as a general contractor, then you're not, right? Why is that not an exclusion rather than a non-offer, a non-offer of insurance?
Yeah, Judge, it can be a difficult issue in terms of distinguishing what is part of an insuring agreement and what is a policy exclusion. The bottom line is that in this court, in Black Bull, drew a line with regard to this particular kind of provision.
Right. I agree, but there was nothing in, the one thing that gives me pause is there was nothing in that case that talked about this modifies your insurance. That's the only thing that gives me pause.
Judge,
why is that not
that
relevant?
language was in the endorsement in the Black Bull case. we cite to the briefs and the
Right.
it was there.
Right,
It's
I
the
guess that's not the part of the record,
It's,
so
it's
that's
the
why I
same,
didn't.
it's the word for word, the same language was in the endorsement to that case. And again, it's simply because it's in an endorsement. So every endorsement has that language. So just to make a simple example.
Are you saying that every endorsement is necessarily a declaration of coverage or non-coverage as opposed
No.
to
What I'm saying is you can't say that something is either a grant of coverage or an exclusion based on whether it's contained in an endorsement.
Okay.
That's all I'm saying.
Okay.
So this whole idea that because it's contained in an endorsement, that magically makes it an exclusion, that's not correct.
And your view is that we've already decided this in another case?
Already been decided.
And there's no reason to go back
it can be
to
as you said, Judge, it can be a tricky issue, but it's been resolved already. So there's no reason why it needs to be revisited here because, again, it's already been resolved. Just to take an example, the insuring agreement in the base policy form says this coverage applies to damages for bodily injury or property damage, okay? If you have an endorsement that says we're modifying that language to say we're only covering for bodily injury, that's not an exclusion. That's simply redefining what the insuring agreement is. That's what we have.
The same person in this case could have been covered, the same contractor could have been covered on day 3 and not day 12, depending on what they were doing. That's why. Because
the insured is presumed to have read and understood the policy. So the insured has to know what's covered. We cover the specific work that if you perform it, you the named insured perform this work, it's covered. Otherwise, it's not. So yeah, if this incident occurred as a result of, even if they were also a general contractor, if they were also themselves performing any of the framing work or whatever it is that's covered, and the accident resulted, there'd be coverage, right? So they know going in, if they're acting as a general contractor, it's not going to be covered because that's a far more expensive classification. So that was the decision they made. And this whole idea that this endorsement was inserted later in the policy, even though we say it doesn't matter, there is no evidence that that is the case. Endorsements are always part of the original policy. There's nothing in the record that indicates this is anything other than that situation as well.
Thank you, counsel.
Three quick points, Your Honors. Not only does the provision say that it modifies insurance, they treated it as a specific modification.
But didn't the endorsement in Black Bull have exactly the same language?
I believe it did. I don't know. It's not in the record.
If it had exactly the same language there, why is it? I don't understand then how you're distinguishing that from this case from Black Bull.
2 reasons, Your Honor. The modification language, it wasn't raised, it wasn't briefed. The panel didn't have an opportunity to consider the effect of that modification language, number 1. But number 2, the issue of whether the CLE in Black Bull applied had no bearing with respect to modification because the original classification in Black Bull was demolition, and the underlying injury that occurred in Black Bull had nothing to do with demolition. So they raised, the defendant raised the issue of the CLE, and the panel determined that it wasn't an exclusion because it really had no application to the case to begin with. So it's not, the issue of modification had no bearing in Black Bull because it never applied to begin with. Here, it specifically modified the insurance contract, number 1, because they said it did. When they denied coverage, they didn't point to the classification page. They pointed to the endorsement that was inserted later that quote unquote modifies coverage. That is an exclusion. Now, my adversary says it wasn't inserted at a later time. Well, it says it modifies insurance already provided. So I believe under this court's precedents, defining what an exclusion is, this court's precedents giving meaning to every word in a provision, this court, and given the fact that they treated it specifically as an exclusion when they revoked coverage a year later, not pointing to the original provision of the insurance contract, but rather pointing to this exclusion, the court should not rely on Black Bull and should apply the plain terms of this agreement. Thank you, Your Honors.
Thank you. Thank you both. Kingsbridge versus, oh no, excuse me, Walsom 316. 2 minutes, counsel.
May it please the court. My name is Gotti Gorn from Meister, Seelig & Fine, and I'm here on behalf of Appellant 316 Bowery Realty Corp. And even though Respondent Walsom failed to submit a respondent's brief, I'd like to take a couple of minutes to highlight certain points in support of our position. First, Bowery's request to amend its counterclaims and dismissal of its breach of contract claim, it's warranted based upon this court's 2021 decision upholding the indemnification limitations in section 14.1 of the 2024 PSA, and the fact that each party reserved their rights in certain settlement agreements to claw back their excess contribution towards a resolution in an overcharge proceeding.
I have a very simple question. Why did your client pay $1.6 million to the tenants if it believed its liability was limited to $250,000?
That's a good question, Your Honor, because there was that pending overcharge proceeding where they were just mounting fees. There was a judgment. And because we felt comfortable, just how Walsom similarly felt comfortable paying $700,000. Again, just for take a step back, Walsom believed they didn't have to pay anything. They believed that Section 14.1 did not exist. They believed that Section 10.13 required us to pay more. They had common law theory, and they also relied on these unrelated assignment and assumption agreements. So both sides, Walsom and 316 Bowery, paid more in order to buy peace in that action. And in doing so, they said, okay, we're going to punt this issue of whether or not Bowery is responsible in their indemnification obligations to a later date because it was mutually beneficial to buy peace in that overcharge proceeding. And Walsom, Your Honor, if I may take it one step further, Walsom agrees. Walsom has conceded this very, very point. They state, and I'm quoting here from a complaint that they filed in their other action. This is a quote. Bowery paid $1.6 million subject to a reservation of its rights from Walsom, of its rights to claw back from Walsom all amounts in excess of $250,000. Respectfully, those are Walsom's words, not mine. Walsom also made a similar point before this court and the trial court in March 2020 and in June 2021, where they say, and I'm going to quote again, under the terms of the settlement agreement, Bowery and Walsom expressly reserve their right to assert claims against each other. Again, context is important because at that time, there was still an issue concerning the indemnification obligations. So again, Your Honor, Bowery and Walsom both made that decision to let's buy peace in the overcharge and resolve it, which respectfully is what occurred when this court rendered its January 2022 decision.
Thank you, counsel.
Thank you.
Kingsbridge 2005 versus Wells Fargo Bank. Judge Gesmer is recused. Counsel.
Good afternoon, Your Honors. Aaron Lockheimer, Morrison Cohen, on behalf of appellants, plaintiffs. Your Honors, the borrower's appeal from the lower court's decision denying their motion for a preliminary injunction, they merely sought disbursement of funds from a reserve account to pay third-party vendors because the lower
It's a
court...
mandatory injunction you were seeking here?
Yes, it is, Your Honor.
Rarely granted, right?
Admittedly so, Your Honor.
You have to show, I mean, we can go over the law, a clear right to the relief. And how have you met that? I mean, aren't there even, frankly, even on likelihood of success of the merits, put aside irreparable injury, I mean, there are really issues of fact.
Well, I think, Your Honor, the record on appeal and the record was developed at the injunction hearing. There are now more causes of action, but the four that were at play at the time the complaint was pending, excuse me, Your Honor, there was claims related to the borrower's ability to sell certain properties, and there were declaratory judgment claims related to the disbursement of funds and the failure to disperse funds. With respect to the ability to sell the properties, the record that's been developed is that between the loan agreement and lenders or respondents' own admissions and documents, that my client has the right to sell the property. There's one property in particular, a 20 Kingsbridge property, for which there's a purchase option that the lenders granted. They consented to the purchase option, I should say, and the purchase option, respondents admit, does not contain language requiring the sale of any other properties. as part of the portfolio. There are 7 properties that are part of this portfolio. So with respect to that claim, Your Honor, we would submit there really is a very great likelihood of success in the merits for our claims based on respondents' own admissions. This has nothing to do with what we say. Has to do with what they say. And with respect to the enforceability of the notice of default, again, and I misspoke a minute ago in terms of disbursements. The other claims related to the notices of default and the enforcement of those notices, the elements of the defaults that were alleged, excuse me. Again, they acknowledge it's disputed, and we've gotten concessions or admissions from the respondents during discovery that, in fact, with respect to the failure to fund this reserve account that's at issue, there was an acknowledgement by respondents that there was an agreement to fund on a timeline, and then without any warning, without any notice, lenders whipped around and said, never mind, we're not going to give you what we said we would give to you. We said it in writing, and they changed the terms. So we believe we are successful on that claim. With respect to the failure to turn over the termination fee, borrower did cure that default. They turned it over, albeit late. I concede that, but it was turned over. And Your Honor, I think it's important to note, Justice Ostrager, at the conclusion of the hearing, at the injunction hearing, he said, and these are his quotes, that the lender was engaged in, quote, bad faith and highly questionable behavior and had likely, quote, waived the, quote, technical default on which it relied. So to Your Honor's question about whether or not we have a likelihood of success in the merits, I believe Justice Ostrager's findings on that regard are very, very informative. And I think that's why Justice Ostrager, the one part where obviously we disagree with him, is when he said that he reluctantly found that we did not demonstrate irreparable harm. Well, Your Honor, the loan agreement makes very clear that on questions of reasonableness, borrower's only recourse is a declaratory judgment for an injunction or for injunction.
In other words, you can't get money damages. Is that
correct?
What you're
And
saying?
Justice Scarpella.
But what about for interference with contract business relations? Wouldn't you be entitled to money damages there?
Those
if you prevail?
Yes, Your Honor. In the amended
So that money damages are available, right?
Well, but those claims, Your Honor, highlight behavior related to the failure to disperse the funds, but also relates to conduct independent of the failure to disperse funds. The injunctive relief being sought has nothing to do with those claims. So it's bifurcated, if you will, to pick up a case earlier. And I guess I'll pick it up on rebuttal. Thank you, Your Honor.
May it please the court, David V. Mignardi of Holland & Knight on behalf of the respondents. This is the third motion that the borrowers have brought, essentially seeking this relief. They sought it in the lower court denied it. They brought almost a replica of this motion to this court. This court, via panel including Justice Singh and Justice Scarpella, denied it. They're not entitled to this. They need to establish a clear right to this relief. It's a very drastic remedy. And the lower court properly found that there was no irreparable harm here. There are circumstances, Your Honors, when a prohibition of pursuit of monetary damages can allow for danger of irreparable harm.
Why not in this case?
But not in this case, Your Honor, because in all the cases cited by the borrowers, none of those movements were seeking turnovers of money. Here, that's what the borrowers are seeking. They want us to turn over money so they can pay their vendors. And
is there any evidence that they can't pay their vendors without the money?
Well, we would respectfully submit that they can pay it. In fact, they
have been paying.
They have been paying.
There are no defaults going on. They've been paying their vendors.
Yes, and in fact, they said in their at the lower court hearing, Your Honor, that we incurred nearly $10 million in 18 months prior to commencing this action. And on testimony, one of the borrowers' representatives admit that we've satisfied those obligations. So they're seeking a turnovers of money, but they have control of the monies because they're not turning over all the rents to us. This is a case where they're seeking.
And they're taking the money to pay the vendors out of that money, right?
Well, Your Honor, we don't have all.
Okay.
They're only turning.
That's true. You don't know.
Yeah,
I get it. Okay.
The rent rolls demonstrate that these properties are turning off nearly $1.4 million a month, and that and borrowers' representatives below admitted we're only turning over approximately $700,000 a month to the lenders. So therefore, about $700,000 per month is being unaccounted for. So presumably they do have access to monies from which they can do that. There's really no irreparable harm here. And just getting quickly to the point about the likelihood of success on the merits, borrowers, my adversary admitted that the sales fee was ultimately submitted, but it was after acceleration. And there's case law that we cited in our papers, Your Honor, that you can't cure default after it's accelerated. That does not unwind a default, much like just accepting post acceleration payments for debt service doesn't unwind an acceleration. There has to be, as this panel is likely aware, with all case law going on regarding the Foreclosure Abuse Prevention Act, there's got to be a lot more to undo an acceleration. So these defaults were admitted that they occurred below, and they're uncured and unwaived. So therefore, there is no likelihood of success to merits on those claims. On the defeasance, there's also no likelihood of success to merits. My adversary said that we've admitted they can sell the property, but that's not what it's at issue. What is that issue at? What defeasance amount? The only defeasance amount they offered below was $1,125,000 on a property that they're going to sell for $12.8 million. We posed questions at the hearing. There's two proposals or two formulas, and it has to be the greater of the two. Do we even know what the borrowers computed the other formula to be? There was no answer. So how do we even know that that 1.125 is the greater of the two? So therefore, they haven't established a clear right to likelihood of success in the merits on their defeasance claims honor either. And unless the court has any other questions, we respectfully submit that this court should affirm.
Thank you, counsel. 2 minutes, counsel.
Thank you, Your Honor. Justice Scarpelli, with respect to your question in terms of vendors being paid, as we've set forth in the record at 1011 through 1012, there's testimony from the borrowers that there are vendors who are not been paid. I could tell you that I've seen letters threatening, lawsuit letters from vendors who have not been
What's
paid.
happening to the money that's coming into that account that's not being sent to the bank, to the lenders?
So some vendors are getting paid, but
The
that's,
vendors are getting paid, right?
well, not all of them, and that's what in the ones that have not been paid are the ones that are supposed to be paid out of the reserve account, which I don't think the borrowers dispute. They're just the lenders dispute. Excuse me. They're really taking the position that because they've alleged a default, which again the lower court called into question, they don't have to pay these vendors who are now threatening to sue my client for failure to pay. In terms of the mandatory relief being sought, you're on. Specifically, there was two cases we cited. There was the matter of Rockwood case, which is this court's holding, but also Justice Scarpelli, your holding when you were Supreme Court Justice in Overtime Partners. That case involved a mandatory injunction. It was requiring the signing of a lease. So the notion, that mandatory relief is not always granted.
It's a drastic remedy, and you have to show a clear right.
Yeah, the problem is you can get money damages here unless there's no doubt. You testified to it. We're looking for $1.8 million. That's what you testified to. So if you can get money damages and there's no irreparable harm.
Your Honor, respectfully, that $1.8 million that's in a reserve account, that can never go to my client. That can't go to the borrower. That money is pursuant to the loan agreement, goes to a reserve account to pay vendors. It has to be approved by the lender.
But the fact is, that's what you're looking for, money.
But it's not money it's never going to go in my client's pocket. It can never. The lender would never allow it.
100%. Yes.
So it's not damages. Damages are money that my client, at least we would submit, is money that my client can collect and put in its pocket. That money that's in the reserve account can never go there.
Okay.
Thank you, Your Honors.
Thank you, counsel. Thank you both.